I mean, I really have no desire to depose the experts. When I last spoke to Mr. Hag in November at our corporate representative deposition, he indicated he wanted to depose our experts. If that's not the case, that's fine by me. That, you know, I don't want to speak for him.
It's generally this court's policy not to continue a case because mediation hasn't happened.
Okay.
But it looks to me like there's still some discovery that needs to be done in this case, potentially.
Okay.
I'm going to reset this, but it will probably be later in the summer. It's not going to be a long reset.
Okay.
Right. If you all need a new docket control order, just submit an amended agreed one.
We will, Your Honor.
All right. Have a good day.
Okay. Thank you very much.
Take care. Come on up on Valencer versus Houston Restore Pros. For those of you that just came into the courtroom, what are you here on?
Your Honor, I'm here for a default judgment on Natalie Daniels, case number 3, when my clients are not here yet. They're supposedly in security. But I got 3 of them.
Okay. Deputy, is he here on a case this morning? Yes.
He's here to deliver something for his father. That's what I got.
Give it to Ms. Briggs, please. All right, tell me what's going on this one. I know there's a reconsideration that's pending and was set on my submission docket, I believe, yesterday.
It was, but we're here today on my motion for a status conference. This kind of comes from the confusion from that motion for reconsideration, and clarification is really necessary because, as you are aware, trial starts next week. On the 15th, we're preferentially set in front of you. Just a little bit of background. July 28th, I had set a motion for reconsideration I had filed a motion for reconsideration in your court of a July 20th order. I can go into why that needed to be set, but I don't think that's important. You did hold a hearing and you granted that motion on August 26th using plaintiff's proposed order. I have a copy of that. It was also refiled, but it's also in your record. Then on December 12th, you had granted my 166 motion. That's a couple months, 5 months ago. And so here's where the confusion kind of started. I spoke to the clerk about this last week. It appears on March 23rd that plaintiff's counsel called the court's office and set a hearing on a motion for reconsideration without ever filing a motion for reconsideration. So because of that, it appears that my motion for reconsideration, which was already granted by the court in August, was then put in front of the court again, because my motion was the only one in the docket, only motion for reconsideration that existed in the docket. So then the court entered 2 orders on March 25th and 26th, denying my motion for reconsideration, which was once again already granted. And then on March 30th, plaintiff finally filed its motion for reconsideration. There was some confusion about the hearings. It was in the court's calendar as April 1st, as noticed by the plaintiff as April 2nd. Motions for reconsideration are supposed to be on the court's submission docket. So it was then moved to the court's submission docket of Monday, which gave us less than 10 days notice. I mean, we had less than 3 days notice for anything because motion wasn't filed for the 30th, but that's neither here nor there. The issue in front of the court today is that those March 25th and 26th orders, which without notice to me, somehow my motion got reset and then denied.
Brief clarification, Your Honor.
Sure.
The short answer is no. The orders the court signed that my colleague complains about conform exactly with the court's ruling from that hearing. And they are nearly identical to the order already on file striking their experts. Opposing counsel's motion for reconsideration was never reset. We, in good faith, called the court and asked for a hearing date. The clerk gave us a hearing date and she said, well, go ahead and just file your notice. We filed our notice. Then we filed our motion. There is absolutely nothing prohibiting that practice. For instance, if I called the court and said, well, hey, give me a hearing date in about 3 weeks for whatever motion, then the clerk says, sure. Ask me for my bar number. I file a notice of hearing. I don't need to have my motion precede that, so long as my motion provides counsel with sufficient notice. But that issue is completely moot because realizing the error of setting it on an oral hearing, and that's on me, Your Honor, I apologize. The clerk reached out to all the parties and let us know that it would be set on submission as it should, awaiting the court's review and ruling. And then we would meet today to also discuss any lingering issues from that. So the defendant's complaint here is moot.
My complaint is not moot, Your Honor. I don't have the 26th order in front of me because it wasn't imaged, but here's the order that you signed in August. This was, as you can see, it was a proposed order submitted by plaintiff, which granted my motion for reconsideration. The thing was, your order striking the expert didn't strike him just as an expert, it struck him as a fact witness, and he is a fact witness. And it was based that that motion was based on hallucinated AI case law. The plaintiff agreed to pass the hearing for some reason, even though it was passed, it was still put in front of the court and it granted death penalty sanctions. Like I said, you heard us in multiple hearings, you signed that order, but because of the confusion that happened, this is the order, one of the orders that was signed on the 25th. So this plaintiff set this hearing on the 23rd. We did not get notice of the hearing until the 27th. That was after the court signed 2 orders denying my motion for reconsideration. And when I called the clerk's office, I was told that the reason my motion got put in front of the court is because the only motion for reconsideration that was on file when that hearing was set was mine. And so there is some kind of confusion. I'm not here on his motion for reconsideration. I just want to know what the court's ruling is on this August 26th order and this March 25th and 26th orders, because I did not have an opportunity to even respond or submit anything because these orders were entered before I ever got notice from the plaintiff. And my motion, it's my motion, which I should be setting, not the plaintiff.
That doesn't conform with the chronology here. Defendant's motion for reconsideration, which I believe was heard last year. Okay. Essentially, what the court's ruling was a reform that order where the witness can appear as a corporate rep and a fact witness, not as an expert. Period. The 2 orders that the court signed, however they got before the court, it doesn't matter because they conform with that ruling. If the court wants to withdraw them, that's fine too.
They don't. The March
may I
26th
finish,
order
please?
specifically, you're
Honor.
misrepresenting to the court.
Okay, please don't talk over each other. You'll both have plenty of time to speak.
So I understand defendants are trying to backdoor an expert in a week before trial. And we certainly object to that. As for the motion for reconsideration, there's nothing confusing about it and there's no prejudice. They had plenty of time. They filed a 50-page response. And we noticed it and placed it on the submission docket according to the court's instruction. As I'm sure my colleague knows, the court has broad authority to manage its own docket. So there's no harm here, and there is certainly no prejudice. Now, if there's lingering issues, and I understand we have trial next Wednesday, I'd be fine pushing it a week and we can resolve these issues if that's the concern here.
All right, here's what I'm gonna do. I'm gonna take a deeper look at this. I will look at this afternoon and get the timeline in order, and I will get you out both an email later today, first thing tomorrow. on
Okay,
this
and
issue.
can I
Thank you,
just
Your Honor.
clarify that we're not asking for the court to change it to August 26th order. We are just asking that the August 26th order, that there be clarification that it is the August 26th order that is controlling, not the March 25th or the March 26th order. If the court would like to hear more argument on plaintiff's motion for reconsideration, we're willing to come in on that, but today's hearing was merely about this August 26th order.
I will clarify whatever I feel like the court needs to clarify. I will get you a ruling later today or first thing tomorrow. Is the case otherwise ready for trial next week?
I did want to say we have submitted all our pretrial documents. Plaintiff's counsel has not submitted their pretrial documents. I've attempted to confer if they can submit their pretrial documents. We are ready to move forward. We've been ready to move forward since December 12th. We are preferentially set. This was a date that the plaintiff chose, and we agreed to. As the court knows, I'm going on extended medical leave, which is why we needed a preferential setting, and I will not be able to come to trial this whole summer. So we've prepped for this. We have everything ready. Our witnesses ready. Witnesses are ready to be here April 15th. I will tell the court, based on your local rules, we probably need a little bit longer than 30 minutes for pretrial, based on the fact that we haven't been able to confer because we do not have pretrial documents from the plaintiff.
Your Honor, again, we submitted pretrial documents last year and they've had them. What they've asked for is we cut them down, or are we going to go on exhibits? And my position was, let's wait on this ruling, which will guide what we present at trial. And I will gladly confer with you. I even sent them an email about that yesterday. So I take serious offense to the misrepresentation that we never submitted anything. We've done it twice as we've been reset, and they've had them all. Now what we need to talk about possibly is cutting them down depending on the court's ruling. But that's the only pending issue. I'm not going to go ahead and just cut things down and agree until I have a ruling, or if necessary, we may seek a continuance. But that's where we are, Your Honor. They've had our pretrial stuff.
And I'm willing to go over those documents with him, but every time I've reached out, he said that he's waiting on a ruling from the court on a motion that was filed less than 20 days before.
Okay. You will likely, in the email you're going to get from me later today or tomorrow, you will likely get a pretrial conference date or sometime next week. If you're going to file a continuance based on whatever the ruling is, please get that on file. And we will take it up next week at a pretrial.
And can we have more than
Thank
30
you, Your Honor.
minutes based on your rules?
You will have more than 30 minutes because I'm going to set this outside of our trial day.
Okay, thank you so much, Your Honor.
You'll have a good day.
Thank you, Your Honor.
Mr. Barnes, what case are you on?
Good morning, Judge. I'm appearing for Yvonne Burton. She couldn't be here today. I'm with the City of Houston. This is the case Ruiz versus City of Houston.
Mr. Molosky, are you still on the Zoom?
Yes, Your Honor.
All right, this is your opposed motion to withdraw. Is that right?
Yes, Your Honor.
Tell me what's going on.
Well, Your Honor, this was a case that I took. The Houston Volunteer Lawyers has a program at the Veterans Administration. A veteran came in. The City of Houston was proposing to demolish the house he lived in. I agreed to take the case. I worked with him through what was supposed to be the administrative process, although at the end of the process, they refused to let me put any evidence on because they said he wasn't a party to the hearing, even though he lived there. We had filed for temporary injunctive relief from their order, which told him to move out within 14 days. And then he died pending. I had actually gone to visit him to find out from the nurses, would he be well for the temporary injunction hearing? They said, you might want to postpone it for 3 weeks. And he died the next day after I saw him. So I have no client. That's my reason to withdraw.
Mr. Barnes, what's your position?
The city, judge, feels that because there's no more plaintiff, the case should be dismissed. I believe Yvonne filed a motion to dismiss yesterday. We don't think there needs to be a withdrawal of counsel, just a complete dismissal of this case. There's no longer any matter in controversy.
Your Honor, I feel like even though Mr. Ruiz is deceased and I don't have a client, I'm very concerned with representations that were made in the document that was filed late yesterday for the dismissal, because the city says no plaintiffs have appeared. Prior to the administrative hearing, there was a whole list of the siblings of Mr. Ruiz, the decedent. Now, I didn't ever ask him if he had a will. I don't know if he had a will, but if he doesn't have a will, this whole list of his siblings would be his heirs. And I don't think, as far as I know, that the city has notified these people that they may have rights they want to adjudicate or continue the issue. I do think that the way the city conducted the hearing, there's some real issues. I don't know whether any of his heirs want to pursue them. I think it's unfair for the city to tell the court that there are no plaintiffs have emerged. To my knowledge, I don't know of anything where they contacted these potential people who might have a right to continue the case.
Mr. Molosky, do you have a list of those potential heirs?
Your Honor, I don't. The city does. The city sent what they claim to be the siblings because he didn't own the property. He was one of a whole group of siblings who were the survivors of their father who died intestate. Mr. Ruiz continued to live there, but they sent notice to all of the people they think had an interest in this property.
All right, Mr. Molosky, I'm going to grant your motion to withdraw. Mr. Barnes, I do see that the City of Houston's motion to dismiss was filed yesterday. It does not yet appear to be set on my docket. Please go ahead and set it on the docket and give notice to those siblings.
Thank you, Judge.
All right, y'all have a good day.
Thank you, Your Honor, and thank you for accommodating the medical needs I had.
Stay well, sir. Happy to do it.
Thank you.
Yes, Judge. Have a good day.
You too. All right, come on up on Wholesale Electric versus Garrison. Deputy, will you call Garrison IE Group, Brian Davis, and Chris James in the hallway?
No, that's your door.
Let me get my docket sheet back.
Go ahead, sir.
All right, thank you, Deputy. All right, so it looked to me like everything was in order with the default judgment. Is there anything that you feel I need to know?
No, Judge.
All right, I've signed the order.
Thank you, Judge.
Good luck
Have a
with your
one.
hearing. Take care.
Appreciate it.
Parties here now on Daniel versus Martinez.
Yes, Your Honor.
Come on up.
One of the players says an infant judge, I told her to stay out there, and then when we meet her, we'll have her come in and have somebody take care of the infant.
Okay.
But she wanted an infant here at the bench, which I doubt her.
No, he may win you some Q points or something. I don't know. This is only as to Sergio Martinez. Is that right?
Yes, Your Honor.
Yeah, but you call Sergio Martinez in the hallway, please?
Judge, I represent the defendant company. Mr. Martinez is not a former employee. He did not cooperate with us, so that's why we didn't have it for him.
Okay.
Just want to make clear that any judgment that is entered against him does not bind me. There is case law on that. That's my only position, Your Honor.
And you've answered in a lawsuit separately, right? I believe.
Yes.
Well, that's a separate matter, Your Honor.
Correct. This will just be an interlocutory default judgment as to him today. Any response, Deputy?
No, Your Honor.
You'll need a record.
Yes. Yeah, you first.
Okay.
Hey, we need a record on the deed. Thank you. Hey, Tosh, can you print something for me? On cause number 2020-81742. Will you print the order on plaintiff's motion for default judgment that was filed February 4th? Yes. Thank you. Have you let me know when you're ready? All right, at this time, the court is going to call cause number 2020-81742, styled Daniel versus Martinez. Would the parties please state their appearances for the record, beginning with the plaintiff?
Donald D. Simone.
Vincent D. Simone.
For the plaintiffs.
Kevin Delgado for the defendant.
And who do we have with us, Mr. DeSimone?
We're starting with Natalie Daniels.
All right, Ms. Daniels, would you raise your right hand for me? You solemnly swear and affirm that the testimony you are about to give in this college will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may proceed.
Before we start, Your Honor, I'd like the court to take judicial notice that all the medical billing and affidavits and records are on file with the district clerk. I can either introduce those as exhibits or we could save the court order some paperwork, and they're all on file. I did check. And also the return of service on Mr. Sergio Martinez, who has failed to file an answer as of today's date. Ms. Daniels, please state your full name.
Natalie Nicole Daniels.
Were you in an accident back on April 18, 2020?
Yes, sir.
That the person that you had an accident with was Sergio Martinez?
Yes, sir.
Were you in the vehicle with Ashley Daniels, Marilyn Thomas, and Desmond Ford?
Yes, sir.
This happened over on Kirby near 610. Why don't you tell the court exactly what happened?
It was an event at the Reliance that day, and I was in the turning lane coming from off Kirby, turned onto 610. The light turned green. I went to turn, and he ran the red light and ramshacked into the passenger side of the car.
Okay, Mr. DeSimone, I'm going to stop you
Sorry.
there real quick. Does Mr. Martinez have notice of today's hearing?
He does not. He's been served and he's failed. to
This
make
court
an appearance.
requires him to be given one more chance, so he needs to have notice of this hearing.
He's been served. I'd have to chase him down and serve him. He's been served. He's failed to file an answer for several years. The defendant refuses to file an answer for him. They refused to even say he was in course of scope. We could get rid of this whole hearing if the defendant would answer their disclosures and say whether this guy was in course of scope of his employment. We've come down to the point they didn't even answer disclosures till 2 years after the statute had run. Then all of a sudden they named a new company. This is what I'm dealing with, Your Honor. So if the defendant would, on the record, say that Mr. Martinez was in the course and scope of his employment, we can eliminate this whole matter, try this case in July like we agreed. But the law doesn't say I have to notify him of the default here. He's been served. I don't know where this guy is. I may never find him. I'd have to pay to get him served with the.
I'm not asking you to send him to find a new address. You can send it to wherever you got him served at.
We had to do substitute of service on that, if you see, attach it to his abode. I mean, I've been chasing this around for 6 years, Your Honor. I can't get, the defense refuses the information, the communication is sparse. I have emailed Cliff Harrison 1,000 times, asked him to file his trial documents. They've never been filed. I have no idea what their position is in the case.
So
They haven't
ask the
answered.
court
I
for
mean,
some
I'm just-
intervention. Ask the court for some intervention. I don't see one motion to compel here.
Okay, well, I understand. I usually try to do things. I usually get well along with most defense counsel.
I appreciate those efforts.
But okay, we'll reset the default hearing then, but I don't necessarily need, I mean, he's been served and he's,
Why is it taking you 4 years to get to a default hearing?
well, because I just figured, you know, eventually the defendant would say, okay, yeah, he's in course and scope, and that's the end of it. I mean, they have filed an answer.
All right, this hearing will be reset. You can pick a date that works for you, Mr. DeSimone.
Okay,
And
and
just
may
send
I ask
us,
this board how you would like notice to be provided to Mr. Martinez?
first class and certified mail to 6510 Colmore Drive, Houston, Texas, 77087.
And is it 10 days notice?
10 days should be fine, as long as it goes in the mail when you say the notice goes in the mail and he's got an opportunity to get the letter before the hearing date.
Okay, I appreciate it.
All right.
Any excuse?
Yes, have a good day. All right, come on up on union funding versus synergy crosslinks. Deputy, another list for you. It's three at the bottom.
These three?
No.
Oh, these two.
Yep.
Good morning, Your Honor.
Good
Michael
morning.
Weems on behalf of the plaintiff union funding
Mr.
source.
Weems, I didn't recognize you. How are you?
I'm good. Staying busy.
I'm getting old. I can't see without my glasses anymore.
I'm in the same boat, Your Honor. Literally, I can't read a thing without my reading glasses these days. If it's acceptable to the court, I'm actually here as local counsel for Padfield and Stout, Mr. Brandon Gibbons.
Okay.
They have their motion for default judgment. We can go through it. They did send notice out to the defendants by first class and certified mail, including of today's hearing. I have copies of the return of service from July of 2025 for each party if the court would like to review.
Thank you, Deputy. I've looked at this default. Everything is in order. Is there anything you want to tell me otherwise?
No, Your Honor. Notice of today's hearing went out by first and certified March 31st.
I
We've
saw
got the
that.
tracking. I believe everything is attached already to the motion for the default judgment, including the affidavits. So unless there's any other questions or concerns, I think I'm going to rely on just the motion and the attachments.
Let me just make sure I have an order. I'm
Yes, Your Honor.
sure I do.
And I did bring copies of everything if the court needs a hard copy.
Got an order and I'm signing it right now.
Thank you, Your Honor.
Good seeing you, Mr. Williams. Take care. All right, come on up on LVNV funding versus Hernandez.
Good morning, Your Honor. Edmund Suji,
Oh, you,
hearing
sir.
counsel for the planning.
Give me 1 second.
Yes, sir.
Does Ms. Hernandez have notice of today's hearing?
I believe so, Judge.
Mariah, do you see anything? The last thing I see is a notice of submission for February 9th. I don't even see that a notice of hearing was set for this.
Hmm.
So you sent an email asking them to, okay, and nobody sent in a notice of hearing? Right.
I believe that's what I think I reviewed from what they sent me, so.
Okay, if you would just have them reset this hearing, have them do a notice of hearing and mail notice to Ms. Hernandez. And otherwise, it looks in order. I just want to make sure she has an attempt to appear and answer.
Gotcha.
Okay?
You're talking at least 10 days?
Yes, depending on how quickly y'all can get the notice out. I want to make sure the mail has an opportunity to get through to her. Okay?
Thank you, Your Honor.
Thank you. Have a good day. All right, how about Jasmine Heights Homeowners Association versus Garcia? Good morning. Yes, come on up.
Good morning, Ricky Dittemore on behalf of Jasmine Heights Homeowners Association. How are you doing this morning?
Doing well. How about yourself? Deputy, would you call these folks in the hallway, please? This one's in blue at the bottom.
It's a beautiful day out. Rather be walking in the park. I picked my second favorite
Soon
place-
enough,
second
soon
favorite
enough.
place to be. And Judge, just to bring it up on our order, the post-judgment interest rate, they put it at 7, I believe it's set at 6.75 now. So we'd ask the court to change that.
No, answer, Your Honor.
Everything looked in order with the default. I will adjust the judgment rate of interest and I'll get that signed later today.
Thank you, Your Honor. Are we dismissed?
You are dismissed. Go and enjoy the park.
Thank you, sir. I won't be doing that, but I'll be dreaming about it.
All right, have a good day. All right, do I have anybody on Hernandez versus Richenberger? How about First American versus Wynn Offices? Come on up. Are you all expecting to be called on the docket or are you just watching?
Your Honor, I just entered an appearance as appellate counsel in the Francis versus Sassel case. I'm here for the jury trial conference.
We'll get you shortly. We've been looking forward to it. Come on up.
Good morning, Your Honor.
Good morning.
Natasha Chiquino on behalf of First American Title Guarantee Company.
Okay, so I think you're having issues with disclosures, interrogatories.
No motions heard on the date of trial. All motions have to be filed. All motions for summary have to be filed and heard not later than 20 days before the trial date. Nobody demanded a jury. Witness lists are due on May the 8th. I'm going to put down 1/2 hour for trial. Trial date will be on July the 27th. July the 27th. At 10:30 a.m. You don't have to file a trial brief. If you do choose to file one, it has to be filed and exchanged not later than 7 days before the trial date. And you were all set. Anything else, Ms. Francis?
No, Your Honor.
Ms. Taylor, any questions, ma'am? Here you go, see.
Yes, I do. I'm just trying to figure all this out and why I'm being sued by someone I do not owe monies to. It's just also new for me, so I'm just really baffled at this point.
I don't know why, listen, I don't know anything about the case. I cannot answer that. They've sued you on a debt. You're saying that they didn't produce the original contract. You can talk to them, explain to them why you think this is a fraud, if that's what you're saying. And you can
Correct.
go from there, okay? We'll
Okay,
work it
thank
out
you.
as we go along. Thank you very much. Have a great
Thank you.
day.
Thank you, Your Honor.
Michael
Thank you,
Bates Chevrolet versus Lauren Vander and Donk, 2505215.
Morning, Your Honor. Diane Boring, Michael Beach Chevrolet.
Your name, ma'am?
Kelly Wise, Michael Beach Chevrolet.
What has happened here?
So we sued Lauren for monies owed.
Yeah, why weren't you guys here March 17th?
They were here, they weren't here. We won it as a default judgment, Your Honor.
Jennifer, can you look at your notes from that day, please?
Yes, Your Honor, give me 1 second. I believe that if I understand it correctly, I believe the plaintiff was here, defendant failed to appear at one point. Then the defendant filed a motion to set aside the default, which was heard on March 17th. And plaintiff wasn't at the motion to set aside.
Correct. So you guys weren't here at their motion set aside, so I set it aside and I rescheduled this for hearing.
We were here, Your Honor. You just,
No.
he had judgment.
Wait.
The first case you called that day.
Okay. You were here on January 27th.
Correct.
I entered default judgment.
Correct, yeah.
They filed a motion to set aside the judgment. She did. You didn't show up on March 17th.
I got nothing for that, Your Honor.
Can you double check our certificate there? I mean, it's right on here. Motion to set it aside, March 17th, 1:30.
Yeah, and the
I
notice
just-
was mailed on 2/6 to the same address that the notice was just mailed for this hearing.
You see what happened?
No, I'm sorry, I don't.
We did mail it to you.
Okay, I didn't get it.
She's on February 6th. She's saying. Did we ever get it back, Jennifer?
No, Your Honor.
So I'm confident we mailed it. Maybe you guys lost it. Maybe the post office threw it in the Franken Poet drain. I don't know, but
This is the only thing I have was today's that we got. This is the first thing we received.
we mailed it. I'm just telling you. And now we don't have Lauren Vanderdonk here, right?
I thought there was on Zoom, yeah.
Are they on Zoom, Jennifer?
No, Your Honor.
Okay, now it's not. Can I see the docket, please? I just don't want this to keep going like this. 8:30 a.m. I gave her 15 minutes. Has the defendant made any payments on this account since you were in here?
Yes, sir. They arrived at the store one day and she did give me $1,500.
I'm going to ask you to raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got.
So, yes.
All right, so you sued. I initially gave you a judgment in the amount of $6,361.60. She's made $1,500 worth of payments since then.
One time, yes, correct, sir.
So the principal sum then, instead of being $62,1660, should be, correct me if I'm wrong, $47,1660, correct?
That's correct, Your Honor.
And then you have court costs of 75 and 70 in terms of filing and service fee. And then you have a total judgment therefore should be 4856.60, correct?
Oh, I didn't have it, so I'm sorry.
Yeah, that's it. So I'm gonna go ahead and enter a default judgment. I hope this is the last I'm gonna go through this. So judgment is entered, 4,856.60. You can go down the hall and they will give you a copy of the judgment, okay? Have a good day. Thank you. Capital One versus Melissa A. Koski, 2600108.
Good morning,
morning.
Jeff Werber, P67124 on behalf of the plaintiff.
Good morning, Mr. Werber. Ms. Koski, your name?
Hi, Your Honor. This is Melissa Koski.
All right. Did you talk to her at all, Mr. Werber,
We
today?
did, and we have resolved the matter, Your Honor. We'd like to place our resolution on the record.
Go ahead.
Thank you, Your Honor. The parties have agreed to enter into a consent judgment with installment payments. The total amount of the judgment, which includes the court costs, is $2,057.45. The defendant is going to make monthly installment payments of $50 starting on or before May 15th, 2026, and on or before the 15th of each month thereafter. I did provide her with instructions on how to make payments directly to my office. The defendant is willing to give me consent to sign her name to that consent judgment and get that filed with the court.
Thank you. Do you understand everything Mr. Werber just said, Ms. Koski?
I do.
He tells me that you are agreeing to a consent judgment in favor of the plaintiff against yourself. Total judgment amount, $2,057.45. If you, in the installment payment provision will provide that you have to pay 50 per month beginning May the 15th of 26 and the 15th of every month thereafter until paid in full. If you miss a payment, there's going to be language in that judgment which would then permit them to set aside the installment payment order and proceed with garnishment of your wages. They cannot garnish your wages so long as you make these payments as agreed upon. They could, if they wanted to, garnish tax returns. Do you understand? And garnish bank accounts. Do you understand that?
I understand, Your Honor.
Do you agree to all those terms?
I do.
Does Mr. Werber have your permission to sign your name to that proposed judgment?
Yes, Your Honor.
Okay, you're all set. Thank you, Mr. Werber. Any questions, ma'am?
I'm okay. Thank you.
Good luck. Thanks a lot.
Thanks, Your Honor.
Thank you. All right, absolute resolutions versus Tiffany Holly, 2600114. Good morning, Mr. Burke. Your appearance?
Good morning, Your Honor. Hal Burke, P69068, attorney for absolute in this case. And I'm happy to say the case is paid in full. Ms. Holly and I had a productive conversation in the breakout room.
Ms. Holly, your name, ma'am?
Yes, Your Honor. Tiffany Holly.
All right, so we adjourned this on February 24th because I was told that you were going to pay this in full by the end of March. Are you going to submit a stip in order to dismiss with prejudice?
Absolutely, Your Honor. She made her last payment, I'm told, by her and by absolute on March 31st. I'm surprised it hasn't been filed, but it will be today.
Okay, so ma'am, and just, you understand what's happening. You paid this, he's going to dismiss the case with prejudice. He has to have permission to sign your name or else he has to send it to you. Does he have your permission to sign your name to the proposed stipulation and proposed order dismissing the case with prejudice?
Yes, Your Honor.
Okay, so I'll wait for that. I'll ask you to get that to me in the next couple of days, Mr. Burke. Anything else?
Nothing further. Thank you, Your Honor.
Have a great day. Ms. Holly, good luck. Thank you.
Thank you, sir.
All right, what else?
It's 5 to 9, so.
Why don't you give me the 9 o'clocks and if somebody's here, I'll call them.
Judge, I don't have any matching parties yet.
Good morning. How are you? Good. All right.
To the judgment.
I gave it to you. So we don't have Speckled Frog Learning Center versus Vanderpool here.
I have Capital One and Herring. Devin Herring. It should be probably the last one on your stack there.
Capital One versus Devon Herring, 2600483. Good morning, Mr. Saloom.
Good morning, Your Honor. For the record, William Saloom, P 41487, appearing on behalf of plaintiff.
Mr. Herring, you have to start your video, unmute and state your name, please. Or Ms. Herring, I'm sorry.
Hi, my name is Devin Herring.
Good morning.
Good morning.
So we adjourned this 2 weeks on April the 7th, or
Yes.
April 7th, I should say. That was back on March 24th.
Mhm.
Have you had any further discussions with her?
Your Honor, I don't know if she's contacted our office. I didn't notice that there were any discussions when I looked at the notes.
All right.
I could be wrong. I don't know if Ms. Herring can elaborate.
So I actually found out within this last year I was involuntarily hospitalized and found out that I have bipolar disorder 1. So I'm waiting on my Social Security disability, and I was manic when I spent that money as well. So that's what I'm waiting on now, is to see if the state of Michigan is going to consider me disabled or not, because that's what's preventing me from working.
Okay, here's what we can do, ma'am. You file a document and answer to complaint where you acknowledge that the debt referenced in the complaint relates to your account. The amount that they're claiming here is $3,708.08 plus costs and judgment interest. What you can do, and I see you're saying you have no money to pay the debt, but what you can do is you can agree to a consent judgment. If you want to, I could put you and Mr. Saloom in a breakout room. And then I can swear you to an oath, and I can conduct a creditor's exam right now and make a determination as to how much you can afford to pay. Does that sound reasonable to you?
Yes.
So do you want to go into a breakout room with her, Mr. Saloom, and try to work out a payment arrangement and explain the consent judgment terms, and we can go from there? And then if you don't resolve the issue as to how much, what the installment payment provision should read like, I'll be glad to go ahead and decide that.
Sounds good, Your Honor. Thank you.
Okay, so we're going to put you two in a breakout room. Thank you both.
Yep, thank
Sure.
you.
Do I have Rebecca Sislow here by chance, Jennifer?
They're in a breakout room, Judge.
So the lawyer for Midland and
Yes.
Okay.
Yes.
What about One Main versus Hardacre?
She's in the courtroom.
Okay, is One Main Financial Group here? Somebody for
I am
them?
bringing them in right now.
Okay, ma'am, you can come right up here. And if you'd like, I see you're on Walker there. You can go ahead and have a seat right at the table or wherever you'd like, okay? So this is One Main Financial Group versus Kimberly Hardacre. And this is file number 2503497. Good morning, Mr. McNally. Your appearance?
Christopher McNeely, P 45664, on behalf of the plaintiff.
Ma'am, your name? You don't have to stand. If you want to sit, if that will make you more comfortable, I have no issue with that. So just take your time. How much is the amount of this debt, Mr. McNeely?
$3,437.55.
Do you agree that you owe that amount?
Not that amount, I do feel that.
All right.
Gonna be payments, accounting payments arrangements with that.
Well, I can do that for you. Okay,
I guess the streets going.
I understand. They can't garnish those as long as you keep them separate. Yes, slow down. Mr. McNeely, I hate to have to send her to a room where she can Zoom with you. She's got a medical issue ongoing here. Do you want to tell me what give me the whole breakdown as to how much is owed here, if you would?
So the damages are $3,437.55. Court costs are $77.25 for the filing fee. And I better write this down as well, Judge, sorry.
It's okay.
$20 for a alternate service fee. There's some other fees for certified mail and whatnot that I'm not gonna put in there. The process server fee for posting it was $44.72. My client does charge a $75 statutory attorney fee. However, my client has stopped interest from accruing on the account as soon as they sent it to my office.
All right, so you have all those figures together. You got 20 plus 75 is 95, plus 44 is 139.72, plus 77.25 should be 213, 213.97. And I want you to stop and correct me if you think I'm wrong. So your total here should be should be 36.51.
I got 36.54 and 52 cents.
Okay, ma'am, do you agree that you owe that amount?
He said he served me. He never served. I got something, you know.
Because they filed a motion for alternate service, but they had the process server go out a few times before that. Then they had to submit the motion. So you were properly served. They are entitled to that.
Oh, no.
Okay, so do you agree that you owe that amount? That being said,
Yeah, I don't know if that found, you know, the original loan was 3,000, I paid.
okay, just keep your voice up for me.
I paid, the original loan was 3,000, I paid 17.
Okay, it doesn't matter.
Okay.
The interest was accruing.
Gotcha. Understood.
Do you have any reason to dispute that you owe the listen to my question. Any reason to dispute that you owe the 3,654.52?
No.
Do you wish to enter into a consent judgment with Mr. McNally along those lines? At which point we can conduct a hearing with regard to installment payments right now if you can't agree. Do you understand that?
Yes.
So do you wish to enter into a consent judgment with his office? And does he have your permission to sign your name to a proposed consent judgment that will be submitted to the court indicating that you owe in a judgment 3,654.52?
Yes.
Okay. Now, I'm gonna ask you to raise your right hand. You can stay seated there. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got. So I'm gonna ask you to prepare a separate consent judgment and then an installment payment order, Mr. McNally. Ma'am, what sources of income do you have? Do you have any stocks, bonds? Nothing else, just Social Security disability. Okay.
I received that's 1993.
Okay. How much do you receive per month?
I received 1788.
Do you have any questions for Mr. McNally?
Not really, Judge. Unfortunately, my application says that she had income of $6,100 a month. So,
Say that again?
My application for the loan originally says she had income of $6,100 a month. So it's crazy that, you know, because they don't tend to lend money on just,
And when did she make her application?
when was this originally? 2024.
Pardon?
2024, June of 2024.
Did you have $6,100? But let's just listen to my question. Let's just listen to my question. Did you have income $6,100 a month back in 2024?
It was joint.
Okay. Are you married?
No,
Well, who was the joint income with?
it was a friend, but they was screwed.
I'm sorry?
It was a friend, but they did not come through with what they were supposed to do. They were gonna help.
How much are you asking for, Mr. McNally?
Would normally be $100 a month. Interest has stopped.
Yeah, I understand. Here's what I'm gonna order, ma'am. You get your check on what? The 6th or 7th?
Third.
The 3rd. All right. $60 per month, starting May the 10th and the 10th of every month thereafter until paid in full, 60 per month. And this order is subject to review. This order is subject to review on motion of either party. This order is subject to review on motion of either party. Just stop. I'll explain it in 1 minute. On or after November 1 of 26. So if you think you're paying too much, you can file a motion. If he thinks you're not paying enough, if you've got other income by them in particular, then he'll have the right, or his office will have the right to file a motion to set aside the installment payment order and increase the payments. Okay? Do you understand everything here? Yes.
Yes.
Okay. All right, Mr. McNeely, anything else?
What was the date, Judge, that it would be a review date? And it's only if one of us,
On or after November 1 of 26.
and it's
So
only
that-
if one of us files a motion.
Correct.
Very
On
good.
motion of either party, on or after November 1 of 26.
I will submit the consent judgment with signatures for both of us, signing for both of us, and a installment payment order that the court has ordered. So I'll just submit that without signatures at all.
Thank you very much. Ma'am, have a great day. We'll send you the orders, okay? Is your consent judgment going to tell her how to pay it? You're going to insert that in there?
You know what? Does she have email? Otherwise, we can send it by mail as well.
Sorry?
Email or.
I heard you. I didn't hear her.
Okay.
Give him your email address.
It's KIM
KIM
HARD
HARD
AC
AC
RE
RE
37
37
gmail.com.
at gmail.com. Okay,
All right. Thank you very much, Judge. We'll send it
have a
out.
great day. Thank you.
Too.
Capital One versus Devon Herring, 2600483. Mr. Salome, your name again, sir.
Yes, Your Honor. Defendant agrees to a consent judgment in the amount of the damage amount is $3,708.08. We have $115.35 court cost, which is the filing fee of $75, service fee $40.35. Total judgment amount of $3,823.43. We're kind of submitting that. I guess we will submit that without payment term. She's indicating she's not working and is unable to make any kind of a payment. I know the court indicated it may want to do a creditor's exam. I have no, whatever the court wants to do, whether without payment terms or.
Principal sum is $3,708. Did you say 80?
No, 8 cents, Your Honor.
Okay.
$3,708.08.
Ma'am, Ms. Herring, do you agree to those, that amount, 382343?
Yes.
And do you understand that he is going to sign your name with your permission to that proposed consent judgment?
Yes.
Any problem with that?
No.
All right, so I can do one of two things. I can just leave this like it is, in which case if you gained employment tomorrow, they could garnish wages. They still can garnish bank accounts if you commingle funds, so you have to be careful with that, and they could garnish tax returns. So I can go ahead and conduct this if you want me to and have a creditor's exam, or you can let this lie and understand that as long as you deposit your Social Security, assuming you receive that disability into a separate fund with no other income going into it, that they cannot garnish that. Do you understand that?
Yes.
What do you want me to do?
I'm sorry, can you repeat it one more time?
Yeah, if you gain employment, they could garnish your wages. If you don't gain employment, they cannot garnish your wages.
Okay.
Okay, because obviously you don't have employment then. But if you gained employment, they could garnish wages if we don't have an installment payment order in effect. It doesn't sound like you think you can work. So I'm only telling you I'll do it either way you want. If you want me to do an installment payment order, I will. If you don't, I won't. And as long as you understand that if you don't commingle any social security funds with other income or other amounts in your bank account, that they cannot garnish those. I mean, they could, but you could file an objection and it's going to be deemed valid.
Okay, yes, I would
So-
like to do that.
So you want me to just have him go ahead and prepare the consent judgment, sign your name and send it over, and we won't have an installment payment order?
Right, yes.
Okay, all right, so that's
Thank you.
what we'll do. Mr. Saloom, you can send that over. Anything else, Mr. Saloom?
No, Your Honor. So we'll sign her name by consent, send it to the court ASAP, and
Thank you. Ma'am, good luck to you. I wish you well. Thank you very much. Have a great day.
Thank you, you too.
People
Have a good day, Your
against
Honor.
Jalen Thomas Mosgrove.
Yeah.
25F51804. All right, give me 1 second here. We have a lawyer on there for the defendant.
He's up. Attorney Corey Westmoreland, appearing on behalf of Mr. Mosgrove.
All right, sir, your name?
Jalen Mosgrove.
All right, so. Hang on 1 second. I set this for arraignment and pretrial on February 5th. He didn't show up per law. We had to issue a show cause. He didn't show up on February 19th. I issued a warrant. And here we are. For purposes of arraignment, how is he going to proceed?
Yes, Your Honor, at this time we are prepared to waive a formal reading. My client stands mute.
Officer, your name? Officer, your name?
Officer Murray.
Has he been printed since he was taken into custody?
I would have to verify, but that would be the usual procedure. This
Can
this
you-
occurred to my knowledge on night shift.
Can you do that for me, please, right now?
Yeah, were you fingerprinted? Yeah. Okay.
All right. And it stands mute waives formal reading, correct, Mr.
That's correct, Judge.
Westmoreland? Would you like to say anything regarding bond? Why wasn't he here?
Your Honor, Mr. Mosgrove is currently residing in Lincoln Park. I'm not sure if he ever received his notice because he had moved. He is gainfully employed working at Rock Foundation. He's not currently on probation or parole. He has no other pending matters at this time that we're aware of. And after speaking with him at length, he did assure me he would be appearing at all future court dates and understands the importance of doing so.
Does he have any criminal convictions?
I don't believe any assaultive in nature. I believe just driving while license suspended.
Sir, can you tell me that? Does he have any criminal convictions to your knowledge?
If you could stand by, I can verify that as well.
That's all right. Find it.
You don't know if he's got any criminal convictions.
He's got some warrants out. You don't like to show up for court. How come?
I just moved.
No.
Warrants for what? Isn't it traffic stuff? I think it's just a ticket.
What?
I
You
think
don't
I
get
have
to
a
ignore
ticket.
courts on show causes. You got 3 warrants out. One from October of 20, the expiration date is October of 26. That was entered back on October 10 of 19. The other one that was entered back on April 6, 26 of 22. The other one that was entered back on April 26, 22. That doesn't bode well for you. Do you work?
Yeah.
How much do you make per week?
Depends, usually from like 600 to 1100.
Sir,
It
was he
depends on
printed?
the hours. What do you mean?
I'm asking the officer if he was printed.
Oh, I'm sorry.
So yes, sir, he was printed. I have a CCH here in
Yeah,
April
I just
6th.
looked at it. I just
Okay,
looked
I
at
don't
it.
see any convictions.
Yeah, that's bad when you don't show up, Mr. Mosgrove.
Yeah, I understand.
Judges don't like that. Here are your bond conditions. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. No contact with the victim, Sophia Aloha. No contact with prosecution witnesses. No assaultive, abusive, or intimidating behavior toward the victim. You're not to enter the property address at 28822 Walnut Creek in the city of Flat Rock. You are not to enter there. You're not to go near there. No alcohol, no marijuana, no illegal drugs, no firearms, no dangerous weapons. Officer, do you have any other information on what happened at the time of this alleged assault?
Sir, at this time, I do not.
Let me see here. Says he pushed the victim multiple times. 3,010%. 3,010%, you're gonna have to post $300 to secure your release. If you do this again, Mr. Musgrove, it will be much, much, much higher than that. Do we understand one another?
Yes.
April
Yes, sir.
16th will be your court date, and that will be at 10:45 in the morning. April 16th at 10:45 will be the court date. You have any questions for me, sir?
No,
They'll let you make some calls.
I don't have anyone to call.
I'm sorry?
I don't think I have anyone to call.
Well, I don't know what to tell you. They'll let you make calls if you need to. I wish. Jennifer, look on the docket, see if Flat Rock's here earlier than April 16th. Will you please?
Yes, Judge.
How much money do you have?
I mean,
Lee?
Judge Hessen has them, it looks
I
like
don't
on the 9th, but
What do you have with you?
I don't have anything with me. I just had to pay all my bills.
I'm sorry. I wish you would have shown up, and I wish you didn't have warrants out for your arrest. It tells me you're a flight risk, and that's how I'm handling it. Good luck to you. Again, they'll let you make some calls. Thank you very much. Also, I hope I said no firearms, no dangerous weapons, no alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. Good luck to you, sir. Thank you.
Thank you, Judge.
Thank you. Do I have Speckled Frog versus Lauren Vanderpool? Are they here on file 217 T
Yes, Your Honor.
227?
Peter Ashek on behalf of the plaintiff, Your Honor.
Ms. Vanderpool, you can start your video, ma'am, and tell me your name, please.
Lauren Vanderpool.
All right, good morning to you both.
Good morning.
This is objection to the garnishment. What is your objection to the garnishment? You didn't really specify on your form here.
Because I didn't know where to start. It has been such a time lapsed 12 years ago for me. It was an unfair allegation from the beginning that I didn't know, and I still don't know how to handle. I just don't feel I owe that money, and I never felt I owed that money. And I'm here today to try to validate that.
Ma'am, you didn't show up at the hearing, right? April 20 of 17, you can't ask me 9 years later to set aside a judgment because something was unfair about the process. I mean, I'm sorry. I don't know what to tell you, but I'm always at a loss as to why some people find it convenient or necessary or acceptable to just ignore court dates. And now, and I got to tell you, if this was improper, anything unfair about this, I would feel bad. But I'm not a mind reader. I can't read people's minds that aren't in the building or aren't on Zoom now at this point about whether the debt is fair or unfair. This has been 9 years.
Yes. Yeah, I understand. I know I've been trying to, I guess I was avoiding it. I felt very defeated, and I felt like I had no way of proving that what they're trying to, I guess, accuse me of. There's no data or documentation.
You graduated high school, I can tell by talking to you, right?
Yes, sir.
You took American government. You had to, right?
Yes, Your Honor.
We have branches of government here, and that makes me feel bad that you have such little faith in the process.
I
Such
was
little.
young and the life struggles I was dealing with as just being a single mother, I don't know why. I have no excuse for why I brushed it off for so long, but the garnishment that they took this year is made a huge dent in our family right now. So it's, I guess, made me want to pursue it, but it should have been taken care of years ago. You're right. I felt like I had no leg to stand on. I've never been financially well off. I've been, low income, and I can't afford a lawyer. I still don't feel like this is fair, and I don't feel like I'm going to win here, but.
Well, wait a minute, slow down. What part hasn't been fair so far? Like when you're kind of, I'm feeling sorry for you and I can help you. But what part do you feel is unfair? You didn't show up. They started garnishing wages. 9 years later, you start to tell me that you don't owe the debt and you didn't show up. You didn't feel like it was fair. That makes me feel horrible as a member of the judiciary. It really does. But that's okay. We don't really need to go into that. How much have you garnished, counsel?
All right, well, Judge, in response, we garnished the 2017 tax refund, the 2018 tax refund, the 2019 tax refund, 2020 tax refund, 2024 tax refund, 2025 tax refund. So this is the first time that there's ever been an objection, Judge. We've had many years of tax garnishments. And of course, being that there's been 9 years gone by, my client has instructed me to continue to garnish her taxes. And that's what I've been doing.
How much is owed on the debt at this point?
$1,534.83, Judge. We have garnished $183 in 2017.
I'll believe you. Give me the figure again. 1,500 and how much?
We believe it's $1,534.83, Judge.
All right. So, ma'am, you're shaking your head. You disagree with that?
I feel like the amount has been different. I've heard several different amounts, and
Well, what do you think it is?
I don't think I owe it at all. I mean, it just goes to show
Ma'am,
that
I
I've been.
cannot go back and revisit a judgment that's 9 years old.
No, I don't blame you. This is because of lost paperwork. They were stating that I was taking childcare but not working. I was waitressing under the table. My pay stubs were handwritten, and my caseworker never turned them in. So it was just something I felt like it was out of my hands, and it just goes to show that I don't have the money for this. In 9 years they've been garnishing it, and it still has it covered at $1,500. Like, I don't make much money, and so it's just. This year they took a lot, and I've been working really hard, and I need a new vehicle. So
Okay.
it's just.
Okay. I'm going to have to find that the objections to garnishment are invalid. Now, so they're going to get to retain that money. Now, I can do this for you. I can have an installment payment order issued now. Would you guys still be garnishing tax returns if she stays in accordance with the payment plan?
Probably not, Judge.
So by law, they could still garnish your taxes. But he's telling me, and he's an officer of the court, he's been around as long as I have, a little longer actually. He's saying that probably if we set up a payment plan, an installment payment order that you stick to, that they're probably not going to garnish tax returns next year. Now, I can't enforce that, but he's telling me that. And until, how much assurance can you give me, Mr. Scheck, that you're not going to garnish taxes if she stays in accordance with the payment plan?
I can make that, that representation, Judge.
Can you put that right on the installment payment order?
Sure.
So let's do this. So I'm going to try to help you here, Ms. Vanderpool. So I'm not your enemy. I'm going to swear you to an oath. You're going to tell me what your income is, okay? And what your living expenses, and I will figure out what I think is reasonable for you to pay. Raise your right hand. Do you solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God?
I do.
Okay. Where do you work at, ma'am?
I work as a delivery driver for FedEx.
Okay, how much do you make per hour?
It's a daily pay, and right
How
now
much?
it's $150 a day.
How many days do you work per week?
Right now I'm 3 days.
So you're only making
Sometimes
450.
2.
So you're making anywhere between $300 and $450 per week.
Yes,
Do you have any children?
I have 2 boys,
How old?
and I reached 16 and 14,
Okay. And you're not married, correct?
and not married. Their father's deceased, so I do receive income for that, for their
How much?
survivor benefit. They get $1,100 each a month.
What other income do you have?
That's it.
Counsel, tell me what you'd be willing to live with.
She has a substantial income, Judge. I would ask for $100 a
Just
month.
asking you, I'm asking you to give me a figure as to what you would be able
I
to
think
live.
$100 would be reasonable, Your Honor.
A month?
Yes.
Can you pay that, Ms. Vanderpool?
I certainly will try.
Well, I don't want you to tell me you're gonna try. I want to help you, but
I have a $1,500 rent every month. I have DTE bills that are astronomical. I'm already struggling day to day, and
Okay.
feeding 2 teenage boys is, whew.
yeah, especially when they're
So-
16, right? One
Oh,
of them
yeah.
16 is eating.
I
house
am
and home.
struggling. I wouldn't be here today if I wasn't struggling. So, I mean, it's a little bit of money, but it's kind of a lot to us right now. So,
Yeah, here's what I'm gonna do. Mr. Scheck, you're gonna put
Yes,
in
sir.
that order, what we just talked about, that there will be no garnishment of tax returns. So long as defendant stays in accordance with the payment plan. So that's what you have to do, Ms. Vanderpool. I'm gonna
Okay.
order that you pay $30 bi-weekly, and I'm gonna give you a little bit of leeway time. We're gonna start that on May the 1st. So every other Friday, starting May the 1st, $30 bi-week. Okay?
okay.
Stay in accordance with that plan. And counsel, you can also put on that order, this order is subject to review on motion of either party on or after November 1 of 26, on motion of either party.
Of 27, Judge?
No, of 26. November 1.
Give me that date once again, Your Honor.
Yeah, this order is subject to review on motion of either party on or after November 1 of 2026.
Okay.
All right?
Yes, sir.
And that is it. And Mr. Scheck, who are you working with?
I don't know what you mean.
Millicent. Who's Millicent? What's the?
Oh, Millicent is my daughter, Your Honor. She's part of
Yeah,
our.
that's nice. That's nice. I thought so. I didn't want to make assumptions, but I see something here in the file that tells me you're working with a relative. So that must be enjoyable. Nice
Yes,
to
sir.
have you here. Ma'am, good luck to you. Next time you have an issue, though, you have to bring it to the court, okay?
Okay.
All right.
One last question, Judge. Should I do that on a 7-day note?
No, you can just submit it to me. You
All
can
right,
just
sir.
submit it to me. I don't need it under the 7-day rule. Just try to get it in the M file today, okay?
I will, Your Honor. Thank you. Appreciate
Thank
the
you.
court's
Good luck
time.
to you, ma'am. I wish you well.
Thank you.
Thank you,
You're
Judge.
welcome. LVNV versus Floyd Morris, 250-2286. This is scheduled for 9:30, so.
Yeah,
I don't know.
Judge, I have a Midland versus Sislo. Do you have that one?
Okay,
Good morning, Your Honor.
hang on one second. I
Oh,
need to
sorry.
find that one. Is that a 9:30?
9 o'clock.
It's at 9 o'clock.
I don't think I have the 5. Do I?
30 should be.
Your Honor.
Oh, here we go. Midland Credit versus Rebecca A. Sislo, 2004682.
Good morning, Your Honor. David Karen on behalf of plaintiff.
All right, do I have Ms. Sislo? I thought I saw her out there. Ms. Sislo, you have to start your video and state your name. There you go. Your name, ma'am. Unmute, please, and tell me your name. You have to unmute.
Rebecca Sislo.
All right, this is a pretrial. Do you guys want to go into a breakout room and talk?
We did, Your Honor. And where we're at is we have done a consent judgment with Ms. Sislo, and she states she mailed it to us signed, but we're not showing it. So we're gonna get that from her signed and then get it to the court. She's made a few payments already on it. It was 2 months ago that we. So if that's okay with the court, not sure if you just want to.
Why don't you update it then? I mean, I hate signing orders that are ordering people to make installment payment orders 2 months earlier. That's the problem. I get when that happens. So,
Yeah,
so let's start over.
Yeah, I'll update it.
I'll tell you what I'm gonna do. I'm gonna adjourn this. I'm gonna adjourn it for 2 weeks, the pretrial.
Okay.
We're gonna, give me a date, Jennifer, please.
That would be the 21st at 8:30.
21st at 8:30. Now, you guys can work on that. You can go back and forth, do whatever you're gonna do, but make sure I'm not signing an order that orders her to make installment payments going back. So you can update it, figure out how many
Yes.
payments she's made, how much to credit, and then take that off. Is that fair?
Yes, very fair.
All right, that's what we'll do. April 21 at 8:30.
Thank you, Your Honor.
Thank you.
Both. Have a good
Bye.
day.
Bye.
Thank you.
Thanks. Capital One versus Syed T. Malik. Is he in here? That's 262503893.
Judge, the 9:30s aren't quite ready. They're still speaking.
Good enough. What else do I have? Mr. Raven Osborne. What is that case? Do I have a file in?
That's an arraignment, Your Honor.
Okay. That's all right. Take your time. A lot of fighters there too. Putting it in there. People against. Raven Lee Osborne III, 21F 234345. Everybody's name, please.
Attorney Corey Westmoreland appearing on behalf of Mr. Osborne. Mr. Osborne, would you please state your full name for the record?
Raven Lee Osborne III.
All right, this is a 2021 incident, February 12 of 21. He didn't show up in 21. I issued a warrant for his arrest. The charge is possession of a controlled substance. Does he stand mute, wait formal reading?
That's correct, Judge.
Where are you now? In the Wayne County Jail, sir?
Yes, Your Honor.
For what?
Picked up on a warrant for our probation violation. I was given a personal bond on it, and I have court on April 28th over it in Lincoln Park for drug court.
You're in drug court and they had a warrant for your arrest because you didn't show up. You weren't a very willing participant, huh?
I was on it. I did very well in the program. I lost my residency, which was only down the street, and I was able to get rides back and forth, and me and my girlfriend had split up, and I had ended up.
You had a warrant for your arrest out of the circuit court arising out of a felony that you pled guilty to, operating while intoxicated, third offense. So you're actually under the jurisdiction of the circuit court, true?
Yes, sir.
It's not Lincoln Park District Court. They gave you a personal bond. That was nice of them, but you don't like to show up in court, it looks like.
No, I show up after seeing the judge. I was unaware. I thought that the medicine had just gotten confiscated because I had drank a lot that night and I was walking. I ended up walking and I ended up having to call an ambulance because I was so cold.
Well, as of this moment, you have actually warrants were issued yesterday for you out of the Third Circuit, 2 of them. And then also out of the Flint District Court, you've had 1. And then also out of the Flint District Court, you've had 1. And also out of the Flint District Court, you've had 1. So you just don't like to show up for court, which is never a good idea.
It's hard for me to commute. I don't have a driver's license at the moment.
I know, but if I told you I would give you $10,000 to get here, you would have done it, wouldn't you?
I would be there. No, I would be there if after I didn't know that I really had court there. I know the Flint thing is just so far, but I plan on taking care of all this stuff right now.
Well, those warrants been outstanding for a long time.
Yeah, 21 years.
Yeah, I know. Right. Thank you. I wasn't going to embarrass you. Can't do this.
I understand. Every time I've seen a judge, though, I've always appeared in court.
Well, that's not true. Why are you telling me that? That's just not true.
I didn't see the judge in
Listen, I don't want to hear it, please. Thank you. Okay. You have somebody you can call to come up with some money?
I have nobody right now.
Even our friends and family get tired of helping us if we're not doing the right things.
All I have is my mother, and she's on a tight budget.
I'm
My
sorry.
mom only had 1 brother and 1 mother, and they're both gone now.
I'm sorry. Is this still your home address, 175 Goodell?
No, sir. I don't know. I'm moving in with my sister on North Huron River Drive, and she's going to help me commute. It's in
Well, hang
Rockland.
on. What is your address?
I don't know. I can't remember. I got ran over. I have a traumatic brain injury, and I have a hard time remembering the address. But I did live there with her for about 8 months, and I'm going back there as soon as I come out of here. I'm going to stay there so I can.
Listen to me. Are you going to remember to notify us of your address? We need a residence to send the mail to.
Yes, sir. I'm going to get all that today. And if I have something in writing, I got a stash of my papers I'm keeping together so I can remember everything. But the serious issue with me going on is they had found a certain type of blood in my cancer. They're not what I have to have further testing of which one it is. It's either Hodgkin's or leukemia, because my T cells and my B cells were depleted in August of last year. I had got.
Jennifer, tell Heather to log on real quick, please.
Judge, she is.
Oh,
I'm here, Judge.
I'm sorry. Okay, here's what I'm going to do. 5,000, 10%. April 16th at 10:45 will be your court date. You cannot leave the state without the consent of the court or violate any law or ordinance. You must appear in court as directed, starting with April 16th at 10:45.
Yes, sir. I'm not
No
gonna
contact with prosecution witnesses, no alcohol, no marijuana, no illegal drugs. Attend AANA 3 times per week in person. This is all obviously assuming that you're posting. And every time you go, you have to have an AA form signed, some notepad, something that will indicate that you were there, that will verify your attendance. So you'd have to have somebody else signing. Every time you come to court, you have to bring that form with you. I want you to put on the bond sheet or on the minimus defendant to see medical. So we'll send him over to the medic, have somebody look at him while he's there. And April 16th will be your court date at 10:45. I hope you can post.
We're gonna need you in there for the plea.
Okay.
The judge isn't available later and the attorney,
Can you,
prosecutor has.
Ms. Francis,
another-
can you shut your, thank you. So that's what I'll do, okay? I sincerely wish you well. We're gonna appoint him a lawyer too, Heather, for that date, okay?
Okay, Judge.
Thank you. Good luck to you, sir.
Thank you, Judge.
Citibank versus Daniel Trozen, 26000186. And I also have counterclaim. Did Mr. Trozen, it looks like Mr. Trozen filed a counterclaim.
Your Honor, plaintiff's attorney is in the breakout room with another matter. He'll be out in just a minute. Miss Francis, though, has the LVNV versus Morris matter, and they are ready.
LVNV versus Floyd Morris, 2502286. Okay, Ms. Francis, good morning.
Good morning. Navjot Francis on behalf of plaintiff's attorney of record.
Floyd Morris.
Good morning, Your Honor. I'm Floyd Morris. I'm here as planned.
Okay. All right. So this case here, I entered a judgment by default, and it looks like you filed an objection to the garnishment, true?
That's correct, Your Honor. I recognize that the court did file, or that I was served rather, and I missed that proper response.
I'm sorry, say that again. What is your basis? What is your basis for your objection to the garnishment?
I wanted to see the documentation and history of this debt, what the interest is, how much fees may have been added to it, and so forth.
Judge, I believe today is a pretrial.
I think it's up for both, isn't it?
No,
Jennifer,
it's a motion on the garnishment today.
Oh, I'm sorry.
There was a default judgment entered in August of 25
right.
after failure to answer.
It does say pretrial Zoom landlord tenant adjourned.
Yeah, it looks like we may have inadvertently scheduled it for the wrong code. That was removed and then corrected, and a new notice was sent out with the.
Yeah, this is his objection to the garnishment.
Okay. Okay.
Do you have his response?
I do.
All right.
And I would just argue that it's a tax garnishment. We have a valid judgment. Him wanting to see documents for the underlying debt is not a valid objection to the garnishment.
You know, Mr. Morris, I mean no disrespect here, but you didn't show up for the hearing back in 2025.
Your Honor, there wasn't a hearing. He didn't file an answer.
Oh, that's what I mean. I mean, he didn't respond, so I entered a default judgment, and he's saying that he didn't have knowledge of this, but process server here says that on June the 13th, they delivered the documents to him, and that Mr. Morris confirmed his identity by saying yes when the process server named him. Are you Floyd Morris? I guess it was. And he said he appeared to be a bald white male contact over 65 years of age, 5'6" to 5'8" tall, and weighing 140 to 160 with glasses, a goatee, and a mustache. So it appears as though you had noticed. I really can't do anything here for you, sir. I mean, I cannot just make up my own rules. They have the right to garnish that tax return. So I'm going to find that the objections to garnishment are invalid. I'm going to need a order from you, Ms. Francis, please.
Yes, Judge.
And what I can do, you live in Trenton, right? So you're not far from here. Are you still driving?
Yes.
You have a valid license and everything?
Yes, Your Honor.
Jennifer, can you make it up to the courthouse, Mr. Morris?
Can I make it to the courthouse today?
Not this second. Can you drive over here to Van Horn and fill out a motion for installment payments? We'll schedule that. And you can tell them that I said I'm going to waive the filing fee. We don't need to have that motion fee paid. I can tell he's got some financial hardships, so I'm going to do that on my own. So Jennifer, can you make a note of that?
Yes, Your Honor.
And you make sure you tell him, judge says he'll waive the filing fee. So you come up here, you fill out a motion for installment payments, and I will set up a payment plan for you in that aspect. Okay, fair enough?
Yes, Your Honor.
Okay, but in the meantime, I have to find your objections invalid, all right?
I'm not saying that I agree with that.
Well, I can't do anything about it, sir. I cannot do anything about it. I can't do anything about it. You might not like it. You might disagree with it. You have the right to appeal it, but I know what the law is, and I know that I can't just willy-nilly go ahead and find objections to garnishment valid when they're not valid.
Okay, I think I understand that, Your Honor, but what I'd like to address is that I would like to review the documents.
Man, sir, you want to file a motion to set aside default judgment, you have at it. But I got to tell you, I'm not likely to grant it when I've got a process server describing you, and he does seem to be describing you, and you had you clearly were served in this case, and the judgment was entered. And we don't just hide these things. We mail out things. You should have gotten these. We don't hide things. So you might disagree with it, but you should have taken steps a long time ago to set aside the judgment if you believe it was improperly entered. You still can file a motion. You want to come up here and file the motion to set aside default judgment, you feel free. But that one he's going to have to pay for. So you want to file that. And if you want to ask me in a separate motion to waive any filing fee on that, you can do that. But I'm not going to just entertain this based on objections being filed to a garnishment. And here you are 10 months later or thereabouts, 9 months later, coming in and saying, I didn't have notice. And it appears to me clearly that you did. So I can't do anything, sir. I'm sorry. That's the way I will handle it. If you have a question, I will answer it, but I certainly don't want to argue with you. Okay? Do you have a question?
No, thank you, Your Honor.
I really wish you well. Okay? If you want to file that motion to set aside default judgment, come on up here. If you want to file a motion for installment payments going forward, I'll be glad to entertain that. Okay? Best of luck to you. Thank you.
Thank you.
Thank you.
Which one is ready now, Jennifer?
Judge, all the 930s are ready now.
All right. So do I have Capital One versus Zayed T. Malin? 2503893.
Right here.
Good morning, Your Honor. Thomas
Morning.
Dukowski, 82958 MBF plaintiff.
Sir, your name?
Hello. Yeah, Zaid Malik.
Did you guys talk, Mr. Duquette, and is there a resolution?
Yes, we did, Your Honor, and yes, there is. I can place the terms of consent judgment on the record if the court would like.
I would like you to, but you have two separate cases, right?
Correct.
So let's make sure we know what case we're talking about as to each one. You want to start with 03893?
Yes.
Okay, go ahead and give me the terms of that.
The damages on this one are $7,317.09.
Did you say 731709?
Yes.
Okay, go ahead.
Damages are 20552.
Cost, you mean?
Sorry, costs. Yes.
Okay, that's all right. Go ahead.
And judgment amount is $7,522.61. There's
hang on, you froze for a second. Judgment amount is what?
$7,522.61.
Okay, Mr. Malik, are there any other terms of it, Mr. Duquette?
Yes, there's a payment arrangement. Mr.
Okay.
Malik has agreed to make an initial installment payment of $1,900. That payment will be due on or before May 1st of 2026. After that, beginning on or before May 15th of 2026, he'll begin making monthly installments of $285. Continue making those payments on the 15th of each month thereafter until he's paid the full judgment amount.
I can see that people are frozen. Mr. Malik, we're going in and out here. We're having internet issues, I guess.
Yeah.
Now, Wait, let me just ask you a question.
Yes.
Do you agree that you owe $7,522.61?
Haven't seen any proof yet, but
Wait a second, slow down, slow down.
Yeah.
What do you mean? He just said you guys went in there and you agreed on that amount. Is that not true?
Yes. I talked yesterday to their office, and they were gonna send a written thing to my email so I could look it over and then sign it. So we just discussed that again like 5 minutes ago.
All right. 752261 is what they claim that you owe. Do you disagree with that, or you're not sure, or what?
No, that's right.
Okay. And he says that you are going to pay $1,900 by May the 1st, and then $285 per month beginning May the 15th and the 15th of every month thereafter until paid in full. Is that the agreement?
Yes. Yeah.
Do you give him permission to sign your name to that proposed consent judgment that he would send over?
No, we talked, and then he said he can send it, and then I can print it out and then sign it, and then send it back.
All right. Is that what you want to do?
Yeah, that'd be.
Okay. But right now you are agreeing to those terms, 752261 in this case, 1,900 by May the 1st, 285 per month beginning May the 15th and the 15th of every month thereafter until paid in full. True?
Yes, sir. Yeah.
All right. So he'll send that to you. I will expect to receive this, counsel, in the next week or 10 days at the latest. Okay?
Understood. Thank you, Your Honor.
So now I'm going to, and any questions on that one, Mr. Malik?
No.
All right. So I'm going to go on to the other one now. Where's the other one?
He'd only had one, Judge. Mr. Malik only had one. The other one's Trosen.
I
That's
see.
two.
Okay, good enough. So that's what I'm doing on that one. Mr. Malik, I wish you well, sir. Good luck to you. Thank you.
Thank you.
So Capital One versus Daniel Trosen. And then I have a counterclaim. Daniel Trosen versus Capital One, 2600551. All right. Everybody's name.
Good morning, Your Honor. Thomas Duquette, P82958 on behalf of plaintiff. Is this Mr. Trosen's file with Capital One or with Citibank?
Actually, I've got a Capital One versus Trosen and a Citibank versus Trosen.
Are they both up for hearing today? We have both files in our office, so I can handle both hearings, but I only show that we had the Citibank file set for hearing today.
I've got them both set for pretrial.
Okay, well, I can handle both. So Thomas Duquette for plaintiff on both.
Your name, sir?
Looks like you're on mute, Mr. Trosen.
Mr. Trosen, you have to unmute.
So I think I'm still in here. I don't know. Should I leave now? Sorry.
You're all set, Mr. Malik. Yes, sir.
Thank you. Bye.
You have to
Mr.
unmute,
Trosen,
Mr. Trosen, bottom left-hand corner of your screen.
Okay, got it. Can you hear me now?
I can. Your name?
Daniel Trosen.
So I'm calling that case. This is again Capital One versus Trosen. And then the defendant Daniel E. Trosen is also the counter plaintiff versus Capital One. That's 2600551. I've got another one here, Citibank versus Daniel Trosen, and then Trosen being the defendant and counter plaintiff on that versus Citibank, 2600186. All right. So I want both of you to tell me your names again, please.
Good morning again, Your Honor. Thomas Duquette, P82958 on behalf of plaintiff on both files.
Mr. Trosen, your name.
Daniel Trosen.
You filed a counterclaim.
Yes.
What is the basis for your counterclaim?
I'm dealing with a company, and they sent letters out to them for the closure, the negotiate and everything.
He's working with a debt settlement company, Your Honor, Quantum Financial. I think that he might have got a form answer as part of that process, and I think that was the basis for the counterclaim. I don't think there's substance to them.
I don't like counterclaims when there's no substance to them, and usually, Mr. Trozen, I'm not
Yes.
saying all the time, but usually they're frivolous. And if I think it's frivolous, and I don't mean to sound harsh or disrespectful or overly aggressive or any other words you can use, I don't like people playing games in the system. I don't see any basis for a counterclaim based on what you just said against Capital One and or Citi. So let's just start with that.
Okay.
Debt settlement companies, they can do what they want. They're not lawyers. They move too slow for me. And I'm not, everybody has the right to do what they do, but they're not lawyers. So let's start with that. So I'll go ahead and give you guys dates, but I'm going to caution you, if they file a motion and you put them through work based on a frivolous claim, I'm going to award sanctions to them. We can't just file lawsuits against people where there's no basis for the lawsuit. Now, maybe you have the one that's going to be the cutting edge and it's going to go to the Supreme Court and they're going to say, boy, this was a good one. And I don't know. I'm just cautioning you. Do you understand what I'm telling you, sir?
Yes.
Good. All right. So I have Citibank versus Trozen. Same thing. Plaintiff counter defendant. Defendant counterclaim. And I'm going to just give me 1 second here. Mr. Duquette, could you give me your P number again, please?
82958.
Mr. Trozen, why do you have Irene Trozen on there, sir?
It's her computer.
Okay. So we need to make sure we put on here for plaintiff slash counter defendant or defendant slash counter plaintiff on this. All right, so I'm trusting there's going to be no resolution today, correct, Mr. Duquette?
That's correct, Your Honor.
Correct, Mr. Trozen?
Correct.
Did anybody demand a jury trial here?
No.
You didn't either, Mr. Trozen?
No.
All right, I'm going to put down 1/2 hour for trial on both cases. If you want to give me the dates, if you have those dates and tell me when I told the other ones the witness list and discovery were due, I'll be glad to insert those.
You want to look at it?
Yeah, sure. Thank you. All right, so here's what I'm doing. Witness lists are due May the 8th of 26. Trial date will be July 27 of 26 at 10:30 in the morning. Both cases will be set for that, okay? Discovery cutoff will be on June the 18th of 26. That's on both of these cases. June the 18th of 26 will be discovery cutoff. No motions will be heard on the date of trial. All motions for summary disposition have to be filed and heard. Filed and heard not later than 20 days before the trial date. You do not have to file a trial brief. If you choose to file one, it has to be filed and exchanged. Filed and exchanged not later than 7 days before the trial date. Okay. And that should pretty much cover it unless somebody else needs to bring something up here.
Not from plaintiff.
You have anything else you want to bring up, Mr. Trozen?
No, right now, no, I don't have anything. No, sir.
You have what?
I don't have anything right now, sir.
All right. Well, maybe you want to talk to them, see if you can resolve it. If you can't, you can't. It's up to you guys. I thank you both. Have a good day. Thank you.
Thank you, Your Honor.
Thank you, Mr. Chosen.
Yeah, thank you, Thomas. Yeah, thank you.
Thanks. People against Quentin Eugene Turnage. 25T6465557. Your name, sir?
Quentin Turnage.
You're charged with failure to pay $248. If I find you didn't pay and you could have paid, that is, you could have paid and your failure to pay was not without your fault, you could be held in contempt and incarcerated 1 day for every $10 owed. You could receive 25 days. You get credit for each day served to the tune of $10. If you paid $148, you'd owe $100. You'd only have to serve 10 days. Do you understand that?
Yes, I do.
Did you sign an advice of rights form here today or not? You're presumed innocent. They have to prove you guilty by a preponderance of the evidence. Do you understand that?
Yes, Your Honor.
You have the right to a hearing. At a hearing, you have the right to question their witnesses, to bring in your own, to use the subpoena powers, the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights. You'll be giving up your right to a contested hearing. And at a hearing, you do have the right to remain silent. If you remain silent, that would not be held against you. Do you understand that?
Yes, I do.
You also have the right to a lawyer. If you cannot afford one, I will appoint you one at public expense. Do you understand?
Yes, I
Would
do.
you like a lawyer?
No, I would not.
You waive your right to a lawyer?
I would
And you understand I would give you one today.
Yes, I do understand.
All right, to the charge you failed to pay $248, how do you plead?
Not guilty.
You want to have a hearing as to whether or not you paid?
No, but Your Honor, can I please speak freely? The reason that I'm saying, well, I guess I'm giving up my rights because I was told I'm outside my window of being able to fight the ticket. So I guess I am.
You what?
Well, they said that I was doing 55 miles an hour.
Yeah, no, but I'm not a revisitor. You didn't show up.
Your Honor, the reason I didn't show up was because, first of all, when I got the ticket, I had just got off the streets and I had just got the vehicle. And I did not remember, the gentleman told me to come in and take it.
If you want to go down the hall and you want to file a motion to set aside the default judgment, you can do that. And you, hang on, but you have to post a bond equivalent to the amount of the fine. So you'd have to pay $248 and then I'll entertain it. But the ticket here was issued back on September the 18th. This is
Yes,
you're way late coming in.
I understand, Your Honor.
Okay? So we can either do one of two or three things. You can tell me, Judge, I want to go down, file a motion to set aside the judgment. I'll explain why I wasn't here for 7 months. And hopefully you'll give me a hearing date. And if you don't give me a hearing date, I understand my bond will be forfeit. You cannot do this. I do not understand this. I will never understand this. I do not understand. So you do what you want. If you want to just plead guilty and do the time, or you want to plead guilty and explain why you haven't paid, but the likelihood of me going back and revisiting a ticket where they've got you going 53 and a 35 and they wrote you for 40 and you didn't show up is about as good as me flying around the room here. So you do what you want. What do you want to do?
I would plead guilty, Your Honor, because I don't want to cause any problems.
They're not causing any problems.
I have a legit reason because I have financial issues that I was going through. Like I said, I just literally got off the streets.
Hang on, slow down.
Everything, so
Slow down.
it's literally financial.
Why are you continuing to interrupt me when I said slow down?
I'm sorry, sir.
To the charge, you failed to pay $248. How do you plead?
Yes.
Did you fail to pay?
Yes, I failed.
How much do you have today?
Nothing.
Why not? Where do you work?
Started the job literally this morning.
Where?
Driving for Detroit public schools.
What is that? $25 a year?
$26.
26. Nice. Good for you. Can't ignore courts like this. You live in Monroe?
No, I don't, Your Honor. That was partially the reason why I did not show up for court, because I did not receive the paperwork.
You got the ticket handed to you. Come on.
I understand that, Your Honor.
I don't want to go through this.
Your Honor,
I don't want to go through this.
I'm not trying to get in this.
I don't want to go through this. They gave you the ticket.
Yes, they did, Your Honor.
You never responded. Come on. I'll cut you a break, but don't make me go on and.
Your Honor, I'm not asking for a break. I paid a ticket in full. I had financial issues. The reason I did not show up, I had no car. My car was stolen.
Sure.
Way to be here.
I'm not gonna make, I don't want. Listen,
I didn't know what court to come to.
come on, you got a ticket in your hand. I don't know what to tell you. You pled guilty to failure to pay.
Yes,
I'll take your plea. And if you just told me you don't have any money today, right?
that is correct.
Okay, so when can you pay this?
It's gonna be some months before I will pay. I'm struggling with paying my rent today.
Sounds like you're blaming me.
No, I'm not blaming you, Your Honor. I'm blaming the black, Your Honor.
Well,
I went through a full divorce and I lost everything that I had. I just literally got an apartment right before.
can you pay $25 a week?
Huh?
Can you pay $25 per week?
I couldn't do it this week, but I could definitely do it probably coming next week, because that'll be the first day I get a check.
Good enough. I'll do that for you. Can you do that?
Yes, sir.
Then to pay $25 per week.
If I
And I'm gonna-
extra and during that week,
Hang on.
could I miss a couple weeks in between the payments?
I'm sorry.
If I pay more than what I'm supposed to pay, man.
I'm gonna start you 25 per week beginning April the 17th. And if you don't have the money on any one of your due dates, all you have to do is call the court. I'll go on Zoom with you. I'll give you an extension.
I appreciate it.
What I don't like is people ignoring courts. So as long as you do that, I don't care how many times we have to do it, I'm gonna be very welcome to it. If I have to do that 32 times with you, I'll be glad to. Just don't ignore courts. I don't get it.
Yeah, I didn't mean.
I know. Good luck. You said you can do this. I'll be happy to do this for you. And in fact, I'll tell you what, but I need your word. You're gonna pay $25 a week starting April 17th. You gonna do that?
Yes, I will.
I'll reduce your balance to $190 as of now, Heather. So we're gonna reduce this balance. I'm gonna cut $58 off of that. All right? Fair enough?
Appreciate it, Marcy.
What a great country.
That's great. Thank you.
Thanks. Take care. Sure.
Got to get when I was at the Secretary of State. I forgot to get where they lifted my suspension.
All right, this was a medical suspension, is that correct?
Yep.
Therefore, based on favorable documentation, license privileges are hereby approved. Mr. Bingham may make an appointment at any Secretary of State office to renew his license. Would you show that to Mr. George? Did you watch a basketball game last night?
No, I don't watch basketball.
No. We did. That's why we're all tired this morning.
John, are we doing a line?
All right. If you get this charge, it will make it, you'll get suspended. You won't be able to get your license back. The Three Rivers City Attorney, Mr. George, agrees to dismiss the driving suspended charge if you plead to a lesser charge of allowing another to violate the motor vehicle code. We use it all the time, the lawyers, prosecutors, and the court. It's a misdemeanor, but it's an odd one. Carries no points, doesn't get abstracted to your driver's license, and it won't affect your ability to keep or maintain your driver's license if you're otherwise eligible, and it appears that you are. The charge is called allowing another to violate the motor vehicle code. The other is you, so it's sort of a legal fiction, but you are allowing another, yourself, to violate the motor vehicle code by driving with either a suspended or expired license. If you plead guilty to that charge, I'm going to give you a fine. I'll give you time to pay it, and it will not prohibit you from apparently getting your license from the Secretary of State.
Okay.
Do you understand?
Yes.
Are you willing to plead to the lesser charge?
Yes.
Where were you going?
I was going to Clear Glass.
And your license was either suspended or expired at that time?
Yes. But I thought it was already taken care of because I turned the paperwork in and stuff after the last time I was in. I sent it to the state and they
Well,
said it would be
Even at best, it was expired, so that'll qualify for this. Do you have an advice of rights there with you?
Yes.
All right, well, good. Do you have to take the driver test all over again and everything?
No, I just gotta renew now.
Well, you can thank Mr. George for this, because this is gonna allow you to get your license and get off the driving suspended merry-go-round. Fine is $100, like the last guy, $125 of cost, $225. Can you pay that today or do you need time?
I can pay it today.
Very good. Doesn't appear that you owe me any other money. What are you doing these days?
Working.
Where are you working?
I work for Bankstar Woods, and I own a business with my dad and work there.
Are you missing work right now?
Yeah.
All right, we'll get back to work. You can go pay the fine, go to the Secretary of State, get your license back, and not come see me anymore.
Nice.
Very good. Court officer will take you down, you can pay the fine and get back to it. All right, thank you. Jameer Young.
Good morning, Your Honor.
Good morning. Let me see what the deal is here. I see you're on my list, but I don't have your case. Oh, here it is. Well, this is weird.
I would say
This is a 2023 case.
Yes,
There's a
Your Honor.
warrant out for your arrest, which I'm about to recall.
Thank you, Your Honor. I was unaware of that. I was made aware yesterday when I went to renew my CDL.
You live in Indiana?
Yes, I do.
You got a ticket on July 30th of 2023 down by south of Constantine, north of Constantine, at Sergeant Morse's neighborhood. They gave you a ticket for operating while intoxicated and refusing a preliminary breath test. Then you didn't show up for your arraignment. I said, see ticket, question mark. So we did an order to show cause. You didn't show up for that. So they issued a bench warrant for your arrest. How come you never showed up for the charge?
Well, when the jail released me and the wife picked me up, I was unaware that I had a court date, but I was in contact with I can't remember who. And like you said, it was a while ago. I can't remember if I.
Well,
paid
the
any monies at
ticket
the
says
time.
appear on August 17th. Then I sent you something and set it for another hearing and you didn't show up for that. Anyway, you're here now.
Yes.
So I'm gonna show you plead not guilty. And so you're a CDL driver, so you need your driver's license.
I was in the process yesterday of upgrading my driver's license to my CDL in the state of Indiana, and it said that the state of Michigan had something holding that against me, which I would assume would be this case. And that's what made me aware, hence why I'm here today.
All right, well, I'll appoint an attorney. Set an attorney pretrial for May 1.
Yes, yes, you're right.
At 8:30, we're gonna be very busy that day. We have a long memory around here. Things seem to come back around eventually. I don't know anything about this other than it was on 131, 2:30 in the morning on July 30th. I don't even know what day of the week it was. You got defaulted on a refusing a breath test charge. But we need to get this case back on track. Are you missing work right now?
Yes.
How far away is Converse, Indiana?
About 2.5, 3 hours.
Well, I appreciate your being here in a timely manner. You have any connection to St. Joe County?
I do not.
Well, I'm gonna give you some paper. You can hire a lawyer if you wish, but I want to make sure you have one. I'm gonna appoint an attorney for you. I want you to call the lawyer and make an appointment to discuss this case with them prior to May 1st. We're gonna have a room full of people in here on May 1st. And it won't be in here, it'll be across the way. But you gotta take care of this. It's from 3 years ago. And it's like a boulder in the stream. So you're gonna need to deal with it. So I'm gonna have the court officer take you out. We're gonna appoint a lawyer for you. We're gonna give you the paperwork. You call the lawyer, make an appointment to discuss it with him. And I'll see you here live on May 1st. All right, you're good to go. Anyway, I think he's gonna need to get printed. I don't know. Okay, you're good to go then.
Thank you, Your Honor.
All right, Sherry Mealer. Good morning, Ms. Mealer. Yeah, he did get defaulted on that ticket. Which one's now? Sure. Ms. Mueller, this is file number 252675. You got charged with a complaint that alleges that on or about October 22nd of last year, you did attempt to break into or illegally enter a building at 207 North Kalamazoo Street. They charge it as an attempted illegal entry, which is about as small as it gets. It's a misdemeanor as an attempt, punishable by up to 45 days in jail and a fine of up to $500. It was a house at 207 North Kalamazoo Street. You attempted to enter without permission. That's the charge. How do you plead to that charge?
Not guilty.
Not guilty? All right, want me to appoint a lawyer for you?
Yes, please.
All right,
Your Honor,
yes.
I live at 207 North Johnson Street, and the person that actually told my boyfriend about that, she was not trying to break the house.
Well,
We didn't know
I
how to
can't,
handle
I didn't make the charge.
it. Right.
Well, maybe we can do a pre-trial. Somebody smells very strongly of last night's alcohol. Somebody walked in here, the courtroom smells like stale exhaled booze.
It's a long night, Judge, sorry.
That wasn't you?
It wasn't me. Iced tea, maybe. But that was not it.
Well, there's probably a lot of hungover Michigan fans this morning, but have a seat, Miss Mueller. What's your name?
Sonia Arnold.
Okay, yes. Laura, who's doing these? Well, Tim's. Would you see if you can get Abigail to do a pretrial this morning on this case? Kyle Singler. Anthony Grant, you need to get arraigned for anything while you're here.
No, thank you, Your Honor. Big rain check.
Thank you, but no thank you.
That's a rain check.
Okay. Good morning, Mr. Singler. You're Kyle Everett Singler?
Yes.
Well, Mr. Singler, I wish I knew what you were charged with.
That's all.
All right. There is a weekend complaint. You're charged with resisting and obstructing a police officer, failing to display license on command of police officer. The R&O charge is now a felony. So I'm going to point a lawyer to help you with this. You still live on Portage Avenue?
Yes.
$500 bond. I'm going to show plea not guilty. Point and a tray. Send to Casey Strong. Set an attorney or set a pre-exam conference for 4/21/26. That will be our first day in the new courtroom. And a prelim if needed for 4/28/26 at 1. Mr. Singler, what do you do? What's your occupation?
I just started a new job and I work for my dad.
All right, doing drywall and stuff?
And irrigation.
Irrigation?
Yep, and drywall. And then get ready to start a real estate business.
All right, well, he's a busy guy. All right, we're gonna get a lawyer to help you with this instead of for a pre-exam. It isn't the kind of thing maybe that will stay as a felony, but I don't know enough about it. It is a felony now, so you're entitled to a pre-exam conference. So I want you to go to the court officer, we'll get a lawyer for you. And I'll see you on April 21st. That'll be on the other side. The bailiffs will tell you where to go when you get here. Abby, I got this odd case. Sherry Mealer is here as an illegal entry charge. And the complaining witness who lives at the house is also here and says this wasn't an illegal entry. So I asked to see if you could do an instant pretrial on that one. Here's the file. The two ladies are seated right there. This young woman is Abigail Stoll from the prosecuting attorney's office. She's going to sit down and talk to you and then see what we need to do. Thank you, Abby. I greatly appreciate it. All right, Craig Cisco. Is Craig Cisco here? John, is your case ready for something?
We're just gonna set it for prelim next Tuesday, Your Honor.
All right. Give me a minute to make a note here and we'll take care of that. Jordan, what do you have for me?
I have 2 PCCs, 1 plea and 1 waiver.
All right. Craig Cisco is here, is not here. This is 26510 OM. He has several other unpaid fines. $790 of unpaid fine and costs. A bench warrant.
Your Honor.
Yeah.
My name is Craig Russo. I don't know if that's.
Craig Cisco.
Oh, yeah, never mind.
Craig Allen Cisco. All right. Bond. $500 cash or surety with a 48-hour hold. All right. Now we've got a couple of pre-trials that Mr. George has done. Looks like quite a few. We have a number of people here for prelims. I'm going to take care of Mr. Bush. She's got just one brief matter. And who's your client, John? Yes.
Real quick, Mr. Crawford also has a trespass with the county. Obviously, I can address that, but I think he's just prepared to take care of everything today. So,
all right, thank you.
We can just stay here.
Kelly Burdick. Well, Miss Burdick, I'd like to handle your arraignment, but I can't find your case.
Is it PEC, Your Honor?
Yes, I'm in the PECs. Well, I don't think I lost it. I think it's just not here. Are you Kelly Jean Burdick?
Yes.
The charge here is possession of methamphetamine as a second subsequent offense. Here with your lawyer, Mr. John Bush. Josh, this is the first of the PECs. I'm doing it to get Mr. Bush on his way.
Didn't know we had started those already.
Well, we haven't really. This is just a special John Bush exception. He needs to get to the jail. Apparently, the defendant wishes to have a preliminary examination in this matter, and that would be set for next Tuesday.
All right, we made an offer of use of methamphetamine. That offer is open today. If she does not wish to accept that offer, that's fine. If the case is bound over at preliminary exam, that offer would be revoked. She's charged with possession of meth with a drug double, which makes this a 20-year. So if she wants to take that chance in circuit court, that's up to her. There will be no further negotiations at that time.
All right, thank you. One problem is you didn't contact your lawyer soon enough. You were given directions to call your lawyer and make an appointment to discuss the case with them. Apparently, you guys hadn't met until this morning, but you did get here and managed to talk to your lawyer.
I called, yeah.
All right, what you're charged with is a felony punishable by up to 20 years in prison. Mr. O'Bear, the chief assistant prosecutor, has agreed to dismiss the felony charges for a plea to a misdemeanor charge of use of methamphetamine. Use of methamphetamine is a misdemeanor. We do a lot of these. It's punishable by up to 90 days in, excuse me, a year in jail and a fine of up to $1,000. If you do plea to that charge, I wouldn't do the sentence here today because I don't know enough about it. I'd set it for sentencing. But if you don't enter the plea, they're going to revoke the offer to the misdemeanor and leave it as a felony with a 20-year maximum. Had you had an ample opportunity to discuss that with your lawyer?
Yes.
And you wish to have a preliminary examination?
Yes.
All right. Are you still on Frisbee Road?
Yes.
That's officially way out in the boondocks. Well, all right, not some trace amounts. All right, so set for prelim. Next Tuesday, which would be April 14th. At 1 o'clock. All right, it doesn't appear that you have any money that you owe. If I gave you a test right now, what would it show? A urine test?
3.
All right. We'll see. We may do one when we see you next, but all right, stay in contact with your lawyer. Judge Pattison will see you next Tuesday afternoon at 1 o'clock.
Will we be on this side or we're going to be across the way?
Across the hall.
So we're going to be in
So
there.
they're dismantling everything Thursday. I expect many bumps in the road. But you're good to go.
Thank you.
Thank you, Judge. Thanks, Josh. That is Kelly Burdick. Why don't we bite the bullet? Bring Mr. Crawford. Do you have anybody else in custody here?
No.
Bring Mr. Crawford back, and that way we can take him back out to the jail. Thank you. That's a 2023 case. Yee. All right, we'll see where that goes. I don't have the cover sheet for that. Every Tuesday, at least by Tuesdays, we have arraignments and then we have pre-exam conferences. Judge Patterson's Tuesday, he doesn't have arraignments, he just has pre-exams. We also have several pre-trials this morning. And let's do a couple of those. Let's do Elizabeth Boyd. So we have to finish those before we can get to the felony cases. Good morning. You're Elizabeth Carolyn Boyd.
Yes.
I met you at your arraignment. You're charged with a no valid operator's license. We adjourned this so you could take your driver test and get your license back, and it appears that you did. So the prosecutor has agreed to dismiss this charge for a plea to a charge called allowing another to violate the motor vehicle code. That's one that carries no points, doesn't go on your driving record, and won't affect your ability to get your license back. Apparently you have it back. Is that true?
Yes.
Good for you. You held up your end of the deal. Are you going to plead to that lesser charge?
Yeah.
Were you driving a car in Three Rivers?
I was.
Way back in September of 2023?
Mm-hmm.
This is another one of those cases that got real old because you've missed some court dates. I think I have $400 worth of bond in here. That day you were driving, was your license suspended?
No, I didn't have
You didn't
my
have one?
license.
All right. So you had to take your driver's test and the whole thing?
Mm-hmm.
Good for you.
Thank you.
These pre-trials don't end up in my queue. Let's see if they put it in here. The good news is you did what you needed to do to get your license, and the prosecutors generally are good about working with people to do that. And we're all better off if you can get licensed and yes, I have $400 of bond. you got arrested in March. You posted the bond. You'd failed to appear a couple times. Did you spend a night in jail before you posted the bond?
No.
All right. There's a $100 fine, a $75 crime victims' rights fee, and $50 state minimum fee. That's $225. You're gonna get $175 of your money back. I don't see that you owe anything. Let me look. No, it doesn't look like you owe anything else. All right, good for you. You won't have to come see me anymore, and that's a good thing. You go with a court officer, you can pay the fine. Well, you won't pay it, you'll get money back, and you're good to go. Thank you. Mr. Crawford, can you see me? There you go. This is Judge Middleton. I talked to you late yesterday afternoon on the video, and I set all these matters for this morning. You had indicated you turned yourself in or you got arrested last Friday. Yeah. And you've been in jail Friday, Saturday, Sunday, Monday, Tuesday. And you're charged with retail fraud, 3rd degree in the city of Three Rivers. You're going to plead guilty to that charge. They're going to dismiss the ordinance violation of retail fraud that took place on January 31st. And you're also going to plead guilty to a trespass charge and file 252055. So let's talk about this. Retail fraud is a misdemeanor. It's punishable by up to 90 days in jail, fine of up to $500 under the Three Rivers ordinance. The civil infraction charge will be dismissed. Trespass under state statute is a misdemeanor, punishable by a fine of up to $50 and up to 90 days in jail. You understand the charges? Yes, sir. And are you going to plead to those two charges? Yes. Other than what I just told you, did anybody promise you anything to get you to plead to this? No. Or threaten you? No. Do you understand that if you do plead to those charges, you'll be giving up your right to have a trial in front of a judge or a jury? That will not be a trial. Do you understand that? I understand. If you had a trial, you'd have the right to be represented by an attorney. All you gotta do is tell me, and I could appoint a lawyer for you. Or you could hire a lawyer of your own choosing if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoena to come to court so they could be questioned under oath. You'd have the right to take the witness stand and testify on your own behalf. But you don't have to because you have a right not to testify. If you wish to testify, the judge or jury could not hold your silence against you. Understand? Yes, sir. All right. You went into the Walmart store on December 2nd. You had a fighting Irish hat, fighting Amish hat. You took some ribeye steaks and then left on your bicycle and perhaps some other things. You were homeless at that time. Yeah. Did you go in there and steal a couple of steaks? Yeah, I see. Well, ribeyes are my go-to. They're expensive, but I guess if you're not paying for them, The cost's all the same. We'll dismiss the other three of us case, which is 264460N. They asked for a total restitution of $135 to cover both cases. I'm going to order 5 days jail credit, 5 days, 0 fine, $75 crime victims' rights fee, a $50 state minimum fee, and $135 restitution to Walmart. You're barred from Walmart for 1 year. That total is $260. Due by January or December 31st. Concurrent with the trespass. 252055SM. You told me that you went into jail, you could see, and you lost your vision since you got arrested last Friday night. Is it getting any better?
Doesn't seem to be, Your Honor, no. I was wondering if you have ambulance calls when you find where you go.
Well,
Get to the hospital.
I'm not sure what to do. I could give you some bus passes, but
I don't think I can walk home.
no, you can't walk home. We're gonna have to figure out something to do with you. You were homeless. Do you have a place to land?
Yeah.
Where's that?
651 Grant Avenue.
Oh, yeah, you told me that with your aunt. Give him a bus pass. They may have to call a bus for him and take him to his aunt's house on Grant Street. All right, let's talk about the trespass charge.
I'm not sure where it's trespassing.
Well, let's take a look. You got a ticket for trespassing on 131, the homeless encampment, I think behind the auto parts store, I think. Had you set up camp out there on 131?
Nah, I got a trespassing ticket for picking my stuff up from the Spartan.
All right, they told you to stay out of the Spartan
Yeah,
Motel.
and all my stuff was packed up and boxed up behind the back door, and they wouldn't let me pick it up. They wrote me a ticket for trespassing. I never even know I was kicked out until I found my stuff at the back door.
And they told you not to come back?
Sam told me, yeah, the guy that runs the place. You know, like,
All right. Did you have a source of income? Did you have Social Security disability or anything?
my fiance, she paid all the bills. He didn't like that. She works for him.
All
I
right,
felt like I was using her or whatever, and I'm still with the same woman. Don't make no sense.
what's her name?
Lori Wilkes.
Will she pick you up?
She can't drive. She's disabled.
All right, well, on the trespass, I'm just gonna give you 5 days credit, 5 days. Have you had these vision issues before?
No.
Well, obviously you're gonna need some medical care, but first thing we need to do is get you at least home. There's no fine for that. I waived it. It's concurrent with your retail fraud. And I give you you owe $260 by the end of the year in 26141 All right, this takes care of all 3 of your criminal cases. One was a plea to retail fraud, one was dismissed. I gave you 5 days credit, 5 days, and the minimum allowable fine and restitution. The other case, I gave you 5 days jail and waived the fine. If they won't get you back to Three Rivers, they can call a bus. I gave you a bus pass. And they can take you to your aunt's house on Grant Street, which is just a couple blocks from the hospital.
Yeah, I'm calling 911. I got insurance.
Well, you don't need an ambulance if $3,000 ride to Three Rivers when you can take an $8 bus pass. So, all right, you go with the court officer, so you're good to go.
Thank you.
All right, we have some more pre-trials that people have been working on, and then we'll switch gears to Mr. Robert's swan song here.
Are we done with what we got? Or are we gonna wait for that one pretrial again?
Oh, she never came back. I wonder if she just dismissed it. Devin Losick. Good morning, Mr. Losick. This is file 26320OT. Are you Devin Allen Losick?
Yes, sir.
Mr. Losick, you were charged with driving with a suspended license. Mr. George, the prosecutor, met with you and he's agreed to reduce this to a charge of allowing another to violate the motor vehicle code. That's the one that carries no points, doesn't get abstracted to your license, and won't affect your ability to keep or maintain your license. Do you understand?
Yes, sir.
Other than that, did anyone promise you anything to get you to plead to this?
No, sir.
You heard me go through the advice of rights a couple times. You understand you have those same rights?
Yes, sir.
Abby, thanks for your help. Okay, I do greatly appreciate her help with that. All right, well, let's take a look at yours. Let me see if they put it in my queue. It did. Thank you, Jenny. You got the ticket at 10:30 at night on February 21st, Michigan Avenue and Joshua Drive in Three Rivers. Were you driving a car at that time?
Truck, yes, sir.
And was your license suspended?
Yes, sir.
And did you get it squared away since?
Absolutely.
Very good. All right, but it was suspended at that time. So this carries $100 fine, $75 crime victims' rights fee, and a $50 state minimum fee, $225. Did a lot of these this morning. Can you pay that today or do you need 30 days to pay it?
These 3 days.
Make that due by May 8th. Two, two, 5 by 5, 8, 26. If you can't pay it, come see me. I'll give you more time,
Thank you.
but at least make some dents on it. And you have your license back now?
Yes, sir.
Very good. You're good to go.
Thank you. Have a great day.
Craig Rudisil. Mr. Rudisil, I appreciate your willingness to take one for Mr. Cisco, but it wasn't you. Wrong guy. All right, you're charged with driving suspended also. Crime of almost every day. It is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. You're also charged with improper display of plates. The city attorney is willing to dismiss both of those charges for a plea to no valid operator's license. That is a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $100. It does carry 2 points and it does go on your driving record. Do you understand?
Yes, Your Honor.
Other than what I just told you, did anybody promise you anything to get you to plead to this
No, Your Honor.
or threaten you? Were you driving a car in Three Rivers on that day, December 28th?
Yes, sir.
Where were you going?
I had just fixed, I had just fixed my truck. I just put a clutch in it, so I went down Lutz Road to hit it up to speed, and then I was going back home. That got me like halfway there. So
And your license wasn't valid at that time?
yeah.
All right, well, this is a much less serious charge. One problem is you got $495 worth of unpaid fines. You have 2 use of controlled substances. Are you on a payment plan now?
Yeah, and we just moved like 2 weeks ago, so I kind of put a damper on things. So I'll be back on track on my payments. Probably Friday, I'll be able to make a payment.
All right. $100 fine, $75 crime victims' rights fee, and a $50 state minimum fee, $225, part of your payment plan. Kind of payment plan where you actually make a payment. All right, I'm gonna have the court officer take you out there. The ladies will get you signed up and make this part of your pay. How much are you paying
I think it was like 75, or it might have been 50.
per month?
Yeah.
Well, that's gonna take a while to get this paid off.
I'll get it back. Yeah.
All right, you can go with the court officer. Miss Mueller. Apparently they want to get more information, so they're going to appoint an attorney and set a pretrial. So I'll set it for May 1. At 8:30. Appoint an attorney. I appreciate Abigail getting more information. Your friend apparently claims she was the owner of the home. Apparently there's another person involved.
Phil's the owner of the home, and she's trying to get a hold of him right now at work, so.
All right. You go out, we'll get a court appointed attorney for you.
Thank you.
All right, that took us until 9:30. Mr. Stickley slowed us down. And thank you, you didn't slow us down at all. We did take care of quite a bit of business. Thank you, Mr. Stickley. I think we're ready to shift gears to our felony docket. I'm just gonna leave stop the record and restart it. Who's on duty this week? Luke. All right, well, let's see what we got. Jordan indicated she had a couple of things. Paul, what do you have?
I just have Andrew Chuck. He was offered a use and he wants to have a preliminary exam, so I wanted to put that on the record. And then Christopher Wired is not here. He was supposed to be here this morning for his pre-exam that was continued from last week.
All right, Mr. Chuck, would you come forward? Are you Andrew Aaron Chuck?
Yes, sir.
We've met. You got your Michigan shirt on. Did you watch the game last night?
No, I did not, sir.
Oh, you're the worst kind of Wolverine fan. Wear the shirt, but you don't even watch the national championship game. Anyway, you're charged with possession of methamphetamine. You had one of these last year and they reduced it to a misdemeanor and you haven't paid the fine for that. No, wait a minute. It was unlawful badge, not a controlled substance. Is there a plea offer here, Mr. Aubert?
Yep, we made an offer of use of methamphetamine. It also looked like the defendant was eligible for a 7411 probation. We'd have no objection to that. But Mr. Gibson indicated his client does not want to take the offer and would like a preliminary exam. If that preliminary exam is held and the case is bound over, that offer would be revoked. There'd be no further negotiations on this case in circuit court.
And I have gone over that offer with the defendant. I showed him a copy of the lab report that was provided. And so I've explained it to him thoroughly and he indicated that he did not wish to accept the plea and that he was asking for an exam.
All right, is that correct, Mr. Chuck?
Yes, sir.
All right. You're entitled to have a preliminary examination where it must be established that there's probable cause to believe that a crime was committed and probable cause that you did it. You don't get found guilty or not guilty at a prelim. If you do have a prelim and the matter has been bound over, the plea offer of a misdemeanor is revoked. Do you understand?
Yes, sir.
There's one extra component, the 7411 probation. If you successfully completed the probation, charge could be taken off your record. Now you owe me a bunch of money, $9,055. Not me, the court. Some of it I can wipe out and some of it I can't, but you're on probation right now, aren't you?
Yes, sir.
Would this be a violation of his probation?
It could be. I've explained to him that he could be found a probation violation based upon this case.
All right. Well, there's a lot going on here. I set for prelim. April 14th, 2026 at 1 o'clock. That will be in the historic courthouse. Mr. Chuck, I ask you this. You were also on Middle Street like the other guy. Your house got whacked during the tornado.
Yes,
That
sir.
way it actually burned though previously.
Yeah, you're correct.
So it was burned and then it got squished by a tornado, so it's about to be an empty lot, I think. But you're still getting your mail there, correct?
Yes.
All right, you're good to go. Judge Patterson will see you next Tuesday at 1 o'clock. Stay in contact with your lawyer. If you do decide to take the plea offer with a 7411 probation, I guess it could still be done at that time. But once the matter is bound over, the plea offer is revoked. All right, Mr. Chubb, you're good to go. Paul, who was your other client?
Christopher Wired.
This is file, would you call the hall for Christopher Wired? Christopher Allen Wired, 26476 FY. He's charged with possession of burglar tools, resisting, obstructing 2 counts, and operating without a license and no insurance. He has a previous unpaid fine.
Always empty.
All right, he isn't here.
There was also 2, I think, misdemeanor
2
cases.
during pre-trials, yes, they were set for this morning also. It appears, didn't he also miss last time?
No, he was here last week. I think he showed up late.
Yeah,
He was
adjourn 1
here.
week to allow defendant time to review evidence, reset for today. All right, on the felony case. He was clearly aware of this date. This is that one where it was charged as being a vehicle, but it was also a house. He had a bunch of stuff with him. All right, bench warrant. Bond was 6,000 cash or surety. Now it's $10,000 cash or surety. 48-hour hold. Notice to revoke previous bond. And the 2 misdemeanors. Bond 250 cash or surety each. 48-hour hold. He's the kind of guy who'll come rolling in about 11:30 this morning. Anyway, it's a pain in the neck when people don't show up when they're supposed to. He clearly knew he was supposed to be here, so we'll give him 40 hours to turn himself in. All right, Mr. Gibson, thank you. You're good to go.
Thank you.
Jordan, let's take your cases. Mr. Evans, you're not wearing a Michigan shirt, but I know enough to know you stayed up to watch the whole game last night. Luke was at the game. I don't know how he got there, but all of a sudden he texted his mom and said he was in Indianapolis. Who are your clients, Jordan?
I have Mr. Trayvon Quinn and Mr. Eli Torres.
All right, which is the plea and which is the?
Mr. Torres is going to be the Haida plea, and then Mr. Quinn is the waiver.
All right, Trayvon Quinn, would you come forward, please? Are you Trayvon Anthony Quinn?
Yes, sir.
I met you earlier. You're charged with assault with intent to do great bodily harm, 2 counts of assault with a dangerous weapon, and possession of a firearm during the commission of a felony. Apparently, you're gonna waive the right to have a preliminary examination in this matter and have the matter bound over to circuit court. I guess continued negotiations could take place at that time. But you won't be having a hearing here today, is that correct? I don't see that you owe the court any money. Are you still at the Erie Street apartment address?
Yes, sir.
There is a bond condition that you not have any contact with Tamika Phillips. Eberron Wilkerson and Ian Brubaker. Do you understand?
Yes, sir.
That's not an issue, Your Honor.
All right, contact is in effect. Are you working somewhere?
Yeah, but we're at Bowling Tire, Best One Tire, Three Rivers.
I use them a lot. I think I've seen you in there.
He is
All right.
engaged with community corrections and complying with pretrial supervision, and I did give him my card today so we can discuss the case in more detail for the next court date.
All right, the next court date will be what's called a status conference. I don't yet know when that will be, but you stay in contact with your lawyer. You're not to use or possess any firearms either. That felony firearm, I'm sure she explained, carries 2 years in prison, flat, preceding consecutive to any other sentence. So don't bring a gun to a fist fight. All right, you're good to go. Stay in contact with your lawyer.
Thank you, Your Honor.
Emilak Torres. All right. This is file number 26503FY. You're Emilak Junior Torres.
Yes, sir.
You're charged here with 2 counts of resisting, obstructing a police officer. Those are felonies. They're punishable by up to a year, 2 years in jail and a fine of up to $2,000. You're also charged with assault and battery and disturbing the peace. Those are misdemeanors. The complaint alleges that on March 21st, you resisted, obstructed Jacob Gardner and Philip Hopkins of the Sturgis Police Department. You assaulted Brandon Day and generally disturbed peace. Mr. O'Bear, what's the plea offer here?
The offer is for the defendant to plead to 1 count of attempt R&O. Our office has no objection to a hide at probation.
Attempted resisting, obstructing a police officer is a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. Prosecutor would allow HIDA, stands for Holmes Youthful Trainee Act. I'm not sure I'm going to do that yet, but we'll decide. If I do it, you could be on a probation And the charge would be made non-public, and it would be essentially removed from your record. You understand?
Yes, sir.
One of the reasons why I don't know if I'm gonna do it is you got convicted of 2 counts of assault and battery in 2022. You never paid all the fine. You still owe $150. You have previous assaultive offenses from 2022. You never paid the fine. So I'm gonna adjourn this. I'm gonna get the police report. I'm gonna get some input from the victim, and we're gonna see if you pay your previous fine.
Your Honor, my client is, I believe it was as of yesterday, is now enrolled in the MCTI program in Plainwell. He's looking to get into the trades. He does have stable housing, reliable transportation. He's in a better place now than he was in 2022, more stable, more secure. It's my understanding he was, I believe, without housing in 2022, and that kind of contributed to that failure. So I will direct him to the counter to get a payment plan set up. Still outstanding fines, but we are in a different position than we were 4 years ago.
Just give that to him. That's the fine you owe. All right, did anybody threaten you to get you to plead to this charge?
No, sir.
Or promise you anything?
No, sir.
Jordan, did you do an advice of rights?
I did not.
I'll just do it here for
I didn't know.
everybody.
He's been in the courtroom since 8:30, so
Yeah,
I,
you've heard me go through the advice of rights a couple of times.
Yes, sir.
Understanding if you enter this plea, you'll give those rights up.
Yes, sir.
What happened? How did this all go down on March 21st?
What had happened was that one of our friends was shooting paintball guns at houses while we were walking. And
speak up.
Yes, sir. And the cops ended up going up to us asking us about it, and we told them we didn't know anything about it, and we walked away. And then we were trying to go hide somewhere, and it escalated. We were trying to climb someone's fence, and then the owner like seen us and told us to get out, and we told him we will. So we got out, and his I don't know if it was his friend or brother came to us and grabbed me by the shirt on the side of the road and was trying to fight me. I told him, please, that I don't want to fight, that I just wanted to leave like his friend said. And my brother, we ended up fighting.
What time was this?
It was like 4 o'clock in the morning.
Yeah, nothing good happens at 4 o'clock in the morning. I was patrolling the area of Michigan Avenue and Walker Street when I observed an assault in progress. I saw 3 subjects that were surrounding another subject in a defensive position on his back. I observed all 3 subjects swinging on the subject in the defensive position. The assault had taken place in front of 513 Walker Street. As I activated my emergency lights, all 3 subjects took off and started running. That's enough for attempted R&O. Elmiak Torres was one of the subjects who was assaulting the homeowner of 513 Walker Street. Elmack was last seen wearing a black hoodie and wearing gray and 1 basketball shorts. Officers were able to identify this individual from a previous complaint that night. Is there another charge out pending someplace, or is this it?
Not that I know of.
This, you're out in the middle of the night doing nothing except waiting to get in trouble. No wonder the guy grabbed you by your shirt collar. I don't know what the deal was. I'll get more information. So I need police report, defendant to pay fine and costs. How old are you?
21.
All right, it's time for you to leave this kind of foolishness behind.
Yes, sir.
All right, I'm gonna set this out a little bit. Jordan, are you available on Monday, May 18th at 10:30?
Yes.
All right. Now, couple pieces of advice. Don't get in any more trouble between now and May 18th. I want to know about your occupational plan. The program up in Plainville was a good one. This wasn't really where you resisted or assaulted the police officers, but you took off and ran away. That's enough for this charge. And I don't know what the deal was about this guy you were beating up. Maybe there's a body cam video that'll help me with that, but you're not charged with that. Monday, May 18th. 10:30. It will be over there. I don't know what number that is. We'll call it courtroom C. By the time you get here, there'll be a system and they'll send you over on the other side. I want you to pay that other fine. I don't want you to get in any more trouble. And I'll get more information.
Thank you.
And you're good to go.
Thank you, Your Honor.
Luke, I believe I've cleared the decks.
Well, Mr. Nosker has the brother slash codependent on that case.
Yes.
So I don't know if it makes sense to do that one next.
Yeah, let's do that next.
Yeah, can we, Judge?
Yes.
This is file number 26501FY. How do you say your name? Alcice?
Alessi,
Alyssa?
Alessi,
LSC Aponte Torres.
that's it.
Is the plea offer the same as the last case?
Yes, it is, Your Honor. We
Yes, Judge.
make an offer of attempt R&L, no objection to height of probation.
What time on the 18th, Judge?
10:30? Does that work for you?
That could work for me, yes.
Two, six. All right, sir, you're charged with the same things as your brother. 2 felony counts of resisting, obstructing a police officer. 2-year maximum, $2,000 fine maximum, assault and battery, which is a misdemeanor punishable by up to 93 days in jail and a fine of up to $500, and 1 count of being a disorderly person while drunk. Prosecutors agreed to dismiss all of those charges if you plead guilty to 1 misdemeanor count of attempting to resist or obstruct a police officer. That's punishable by up to a year in jail and a fine of up to $1,000. Like your brother, they're allowing me to consider Holmes Youthful Trainee probation, which would allow you to have this charge made non-public and taken off your record. Do you understand? Other than what was said here, did anyone threaten you to get you to plead to this charge?
No, sir.
Or promise you anything?
No, sir.
All right, we went through this with your brother. You guys were out the 4 o'clock in the morning on March 21st, which is a Saturday night, Friday into Saturday. And then you got into some disagreement with a guy and the cops came and you all took off. Had you been drinking?
I drank a little bit.
What were you drinking?
There's a can of Cayman Jack, I think it's called.
What's it called?
Cayman Jack, I think it's a blue can.
Cayman Jack. How old are you?
18.
What do you do? Do you work someplace? Do you go to
I
school?
work at Amazon and I'm planning on going to school soon.
Which Amazon?
The fulfillment center in Bristol, Indiana.
What kind of shift do you work?
3rd shift. I just started like last Monday.
Well, that's something. You run the whole time, don't you? I mean, you don't stand around in there. It's go, 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 go.
Yes, sir.
You been up all night?
Yes, sir.
All right. What were you guys doing out there anyway?
Honestly, it was like, it started off, we were gonna walk to Walmart. And we weren't even thinking about the fact that Walmart wasn't open. We were just walking. Our friend had his paintball gun used for the houses. And you know, everything just kind of took a turn when we went to cut the person's yard.
You're lucky somebody didn't shoot you. You guys are out there doing no good. It ain't exactly the crime, it's the kid stuff. And you got a job, which could end up being a good move for you. You have health insurance and benefits and that sort of thing with this job?
Yes, if they like kick in after 30 days, I think.
All right, what does it pay?
$20.50
with overtime?
Yeah, overtime too. We have mandatory overtime.
Well, you're making good money for an 18-year-old kid.
Sure.
Although it's hard work. They treat you like a piece of industrial equipment rather than a human being, but all right, I'll see you at the same time as your brother. I'll get the police report. I'll give you the same advice. Don't get in any more trouble till we sort this out. Or afterwards. All right, we'll just keep plowing ahead. What are we gonna do with Miss Hodson?
Judge, she's prepared to make an admission.
All right.
Elizabeth. It is going to be via no contest, Judge. If I could propose the bond information report as a basis.
All right, thank you.
Yeah. Just on the last page.
Little house cleaning around here. Between now and Thursday, I have to move every single thing out of here too. You're getting out of here just in time as we dismantle everything. This is file number 26529 FY. You're Elizabeth Hodson.
Second Childers, I don't know why they have me on my last.
Well, I'd known you as Hodson, but it's Childers.
Yeah.
Let's take a look. Is Childers in here? The allegation is that on March 21st, that was the same night those boys were out crawling around with a paintball gun at 4 o'clock in the morning in Sturgis. You were alleged to have assaulted or opposed, endangered, or resisted Seth Chittister and Gavin Flynn through his police department. What is the plea offer?
The offer is for the defendant to enter a plea to attempt R&O. We have no objection to a no contest plea. She was very intoxicated. The report indicates she was at a .317. So I think that's a.
Elizabeth, you're on probation for the earlier drunk driving charge. I think.
I don't think I am, no.
Sure. Maybe you just owe money.
I
You
believe
owe
that-
$595.
Right.
Are you on a payment plan?
I am.
All right. That was not good. It was close to your house. That whole, everything where that earlier arrest went down all got destroyed by a tornado.
Mhm.
But this ain't good. A 317 is scary territory. By pleading no contest to this charge, you don't admit what happened, but you also don't deny what happened, and you would allow or accept that a conviction would enter. Do you understand? You have to say yes or no.
Yes.
All right. Oh boy. Attempted resisting obstructing the police officer is a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. Do you understand that by pleading no contest to this charge, you'll be giving up your right to have a trial? There won't be a trial. Do you understand that?
Yes.
If you had a trial, Mr. Nossiker could be there to represent you. All right, this is scary. You weren't far from home, but somehow you ended up down on Hoffman Street, passed out in a ditch. And the police picked you up. Someone reported that you were there and you fell and hit your head, and they took you to the hospital. And then you were combative with the officers at the hospital. Elizabeth became combative, swinging her arms and kicking at the nurse. The hospital staff hates these kinds of cases. Officer Flynn and myself. As Flynn walked away after her jewelry was taken off, she kicked him with both feet, barely missing him. Then she tried to blow snot and spit on the nurse. Yeesh. All right, we got to figure out what to do with this. Let's set this for sentence. Luke's going to be here on May 18th. We'll set it for the same day at 11 o'clock. What are you doing? Have you got back into treatment or rehab or anything?
No. I haven't had rehab or treatment or anything like that.
I want to look at that drinking driving case. I thought I put you on probation.
Honestly, I wasn't driving in that case, and as far as this case as well, I was not driving in this one either.
Well, you're not charged with drunk driving here.
Oh, I know, but I'm just.
I mean, it's close. I'm lucky it freeze to death. March 21st wasn't terrible, but you got it real bad, and you don't seem to be aware of it.
Can I just mention something about that night as well?
Yes.
I have been put on some hefty antidepressant pills that I had just started 2 weeks ago. And I really feel like that was a huge factor in that night for it to be that high. Because
Stop. You're lucky to kill yourself. Your antidepressant pills had zero to do with your blood alcohol level. And may have had to do something with your level of comprehension and intoxication, but prescription medication doesn't affect your blood alcohol level. You drank a large quantity of alcohol, which made you quite drunk. You're mixing it with psychotropic medication, and that is scary stuff. But it didn't raise your blood alcohol level. They didn't.
Me and my wife were arguing. We went our separate ways and argument stopped.
All right, despite this violation, the court's going to continue you on supervision at this time. I'm going to order you to do the anger management class. And how many hours a week are you working right now?
Right now, I'm not. I've been out for 2 weeks, and I was waiting to see what happened.
Those tests were 0.194. I did not put you on probation. Put you on a payment plan. I only charge you $595, and you still owe $595. You haven't paid 1 cent. What happened there?
I am having issues getting employment right now. My daughter had an episode earlier on in the year that I have been trying to deal with. She had a suicidal episode, so I've just been kind of home with her right now, but I am trying to look for employment.
We're gonna have a long discussion on May 18th. Do you think that your daughter's mental health issues might be connected to your severe alcoholism? We're
No.
gonna talk about that. I felt like I gave you a substantial break in that case. I made the fine quite low. I'm very disappointed to see you haven't paid 1 penny on it. You have very little insight into your level of your substance abuse issues. Bring your toothbrush. If you have this attitude when I see you on May 18th, you're gonna get out about Labor Day. So I want you to try to gain a little insight. I also want you to pay something on that earlier fine. I can wipe it out with a jail sentence, but you're gonna hurt yourself. You're gonna kill yourself. Mr. Childers is there quietly acknowledging what I'm doing here. Your family all can see this. That's a Monday. You seem like a nice person, but you need some intervention. I'm going to give you a breath test or a blood test that morning, see what your blood alcohol is at that time. Plus, your conduct was terrible. You're kicking at the officers, you're blowing snot on the nurses. It's just bad. I don't want you to get in any more trouble, and I want you to start to pay on that other fine before I see you on May 18th. You're good to go. I don't know that jail is the answer, but she doesn't even know what the question is. All right, we're plugging away here. We have left quite a bit. Kayla Williams, Lawrence Perry, Elijah Perry, Mr. Perkins, Mr. Kidd, Mr. Fraze. There's a waiver in that one. Who's here in the courtroom?
Judge Mr. Perry is, and Mr. Decker.
All right, let's do Mr. Perry. What are we going to do with him?
Judge, knowing what we have, we're gonna have to talk a little more, Judge, because just found out too that the co-defendant has waived. So I think Mr. Perry's gonna have to come to the office. We're gonna have to talk a little more. So at this point, leave it on.
Leave it on for a prelim?
Yes, sir.
Well, the problem is then they gotta bring in witnesses.
Would be fine if you'd rather adjourn it for a week.
Um,
Talk or,
yeah, that would be, you know.
Go ahead, Mr. Perry, have a seat. Who's the co-defendant?
it was Jordan's client, Trayvon Quinn.
You're just charged assault, great bodily harm, no firearm or stuff like him. Is there a plea offer, Mr. Robert?
No, not really.
Right.
But waiving keeps open the ability to negotiate upstairs in circuit court for whatever.
All right. Mr. Perry, are you living at apartment 107 in Three Rivers?
Yes, sir.
Are you working someplace?
Yes. Bowling tire, been there
Oh,
2 years.
you both work there?
Yeah.
Well, I've probably seen you too. Although I haven't bought. All right, we're gonna continue the pre-exam are you set to be here next Tuesday, Luke?
What do you mean, set to?
Well, the pre-exams would be in the morning, April 8th, 14th.
Oh, they are set to be in the morning?
Yeah.
Well, I think the pre-exam conferences.
Yes.
I do have a 9 o'clock pre-trial hearing via Zoom.
Well, we'll set it for April 14th at 8:30. You guys can continue to discuss the matter.
And is the court anticipating a April 21st
Yes.
preliminary date? And that will be in the afternoon?
Yes. All right, Mr. Perry. I don't see that you owe any money. You're good to go. Stay in contact with your lawyer, set to be here next. Did he get printed? Did you get printed this morning? Oh, wait a minute. He's not on for prints. Are you Gregory Dean Decker?
Yes.
How are you guys connected?
My uncle dates his mom.
Okay. Everybody needs a friend. Somebody needs to be looking out for them. Let's see what we got here. It says here that you owe $2,084 worth of stuff. But most of that isn't you. I think it's your dad. Oh, maybe it is you. This is 26526 FY. The allegation here is that you did carry a pistol in a Ford F-150 and that you were intoxicated while you were doing it. And so they charge you with carrying concealed weapon, which is a felony punishable by up to 5 years in prison, $2,500 fine, the weapon gets forfeited. Charged with operating a vehicle while intoxicated, that's plain old drunk driving, which is a misdemeanor punishable by up to 93 days in jail and a fine of up to $500. Carries 6 points on your driving record and requires your license be suspended. And you're charged with possession of firearm while intoxicated. That also requires the forfeiture of the gun. Is there a plea offer here, Mr. O'Bear?
Yes, Your Honor, the offer is for the defendant to plead to counts 2 and 3, OWI and possession of a firearm and the influence of the felony would be dismissed.
Carrying concealed weapons a felony. They're going to dismiss that if you plead to operating while intoxicated and possession of a firearm while intoxicated. You understand? You've also been waiting here all morning. Here's your advice of rights. You understand you're going to give those up by entering this plea?
Yes.
Anybody threaten you to get you to plead to this?
No, sir.
Or promise you anything?
No, sir.
This is pretty small print. So did you get pulled over at Fifth Ave and Washington Street for loud exhaust
Yes.
at about midnight? Was this 12 o'clock at night or 12 o'clock in the afternoon?
Afternoon.
And had you been drinking?
Yes.
What did you drink?
Just beer.
How much?
Probably 4 or 5.
How old are you?
21.
Preliminary breath test .142. Did you have a gun in the car?
Yes.
What was that about?
Protection.
I think people might need protection from you. What are you doing? Are you working someplace?
I'm just doing the roofs right now.
There's lots of that. Storm damage stuff?
Yeah.
Who are you working for?
Steve Green.
All right. You owe $2,084 of unpaid fines and costs. Most of them are not. There's a drunken disorderly and a resisting obstructing police officer that was reduced. Then you got some traffic stuff. Oh, you sure made a mess of things. Oh, so far. Where do you live?
Did that,
All right, whose house is that?
our mom's,
Okay. So you weren't very far from home.
no,
Where were you headed?
home,
From where?
from a friend's house.
Were you still drinking from the night before? You got up early in the morning and started drinking?
I got up early.
Well, you can't drink all day unless you start in the morning. This is messed up. Anyway, we'll see what we're gonna do here. I'm going to set sentence for May 18th. Luke, we might as well get our money's worth out of that day. But when I block out a morning, I try to share it with just one lawyer if I can. And we'll have 3 of your cases that day. Mr. Decker, we're gonna set this for screening and sentencing. This isn't good. You got a gun in the car, you're day drinking on a Saturday. All this went down on March 21st. Must have been a nice day. You got $1 zillion with unpaid previous fines. You're floating like a cork in the ocean. We'll take a shot at this on April or May 18th at 11 o'clock. You take that out to the counter and they'll give you information. I want you to come back on the date that they give you and we'll do the screening and sentencing. Don't get in any more troubles before I see you on May 18th. I thought that maybe was his dad, but I think all those are him. I don't know what to do with him. All right, let's talk about who's left in the pile. Adam Aiken is Stanku and David Moore's office. Do we know what we're doing with him?
He sent a stipulation to adjourn yesterday that we sent down to the court.
It's probably down there somewhere. As you know, everything's in disarray. Andrew Kidd, arson, 3rd degree.
Judge, we're gonna leave it on for now.
Is he in custody?
He is, Judge. And I'm gonna report back. I'm gonna go visit him tomorrow and talk a little more. We may have a resolution in that case.
Let me make a better note. Is there a plea offer, Mr. O'Bear?
Yeah, the offer was that we dismiss the habituals.
setting all this stuff for April 14th. I will be elsewhere on April 14th, but Judge Patterson will be here. Rihanna Tremaine Perkins.
Judge, for that case, Mr. Perkins intends to waive on the record. He also is asking for a review of his bond.
Kayla Williams.
She may have yet to appear, Judge.
Seems to me she has failed to appear in some other stuff. Hi, Judge Middleton calling. Could I see Rionis Tremaine Perkins in my court? All right, thank you. Bye. All right, Josh, we're on the home stretch. I wore jeans because I got more moving today. You're just moving out. You don't have to worry about whatever the bill
Yeah,
could
I
see
came in on Friday
planted.
and gathered a lot of my personal stuff to get it out of the office.
I intended to, and I got sidetracked.
I did see Matt, and he's registered for the MATCP conference, so.
Good. Well, she had one. Last week in 231596. She'd been AWOL for a while and she got arrested. That case got dismissed on April 2nd. This case was not dismissed. She's on community corrections supervision, or she's supposed to be. This is file 2-3. Have you had any contact with her?
No, Judge.
Bond here is 7,500 PR. I did that. Because it was a mistake. New bond. 7,500 cash or surety. Hello, Mandy. This is Judge Middleton calling. I'm on the bench. Has Kayla Williams had contact with you for pretrial supervision? Well, she has two separate cases. All right, any contact since? All right, well, when you hear from her, there's a bench warrant for her arrest. Tell her she needs to contact her attorney. All right, thank you. Bye. She may be confused. The other case got dismissed and this one did not. She did call community corrections and enroll on Friday.
Was she informed that the case was dismissed?
I don't know. Mandy said she thought she is set to check in on Thursday, so she knows she has some obligation.
It looks like the Nolly was. Oh no, this was a different thing. Was it on the second? That would have been.
It was April
Thursday.
2nd.
Yes, it's possible.
Due bond, 4,700 cash or surety, 48-hour hold.
Thank you, Judge.
This is a 2023 case, and she has a history of failing to appear and being rude to our staff. So she needs to get in here. Laura, would you print me a waiver in Rihanna's Tremaine Perkins? Good morning, sir.
Good
Can
morning.
you hear me?
Yes.
I can't hear you. What's your name, sir?
My name is Rihanna Perkins.
All right, I can hear you now. Yes, all right. Mr. Perkins, this is Judge Middleton. I'm here with your lawyer, Luke Knopfinger. Also present is the esteemed Chief Assistant Prosecuting Attorney, Mr. Joshua Robert. This is the time for a pre-exam conference in your case. I'm advised you're going to waive preliminary examination and ask to address the issue of bond. So give me a minute to get the file up here. Is that your understanding, Mr. Knopfinger?
Yes, Your Honor.
Thank you. Mr. Perkins, the allegation is that on March 23rd of 2026, you were in Three Rivers and you had been convicted of a previous felony offense, which made it unlawful for you to possess a firearm. They allege that you did possess a firearm. That is a felony punishable by up to 5 years imprisonment and a fine of up to $5,000. Requires the weapon be forfeited.
Judge, it was ammo.
Oh, ammunition, yes, not a weapon. And then you're charged with receiving, concealing a stolen motor vehicle, a Nissan Altima. And that is punishable by up to 5 years imprisonment, a fine of up to $10,000. You're charged as habitual second offender, which would make these theoretically punishable by up to 7.5 years in prison. Let's take a look at this. All right. Mr. Perkins, are you gonna waive your right to have a preliminary examination in this matter? Have the matter bound over to circuit court?
Yes, Your Honor. Yes.
Let me read you that language. I, Rihanna Tremaine Perkins, understand I have a right to employ an attorney. I may request a court-appointed attorney. I voluntarily waive my right to a preliminary examination and understand that I will be bound over to the circuit court on the charges in the complaint and warrant. Is that what you wish to do?
Yes. Yeah.
Because we're doing this to preserve an offer to a receiving and concealing motor vehicle, no habitual enhancement.
You agree, Mr. Robert?
Yes.
And before the court signs it, we'd ask to be heard on bond.
Yes, here's your copy, so you can sign it. All right, bond is presently set in the amount of $10,000 cash or surety. All right, apparently they put out a BOL for this car, a Nissan Altima. I found you in it. Belonged to a rental car. Let's look at the bond. The recommendation was to release with pretrial supervision. The order: unemployed, no family in area, no history of substance abuse addiction, nothing pending, not on probation or parole, rides on Fairport Street in Detroit. Mr. Knopfinger, what would you like to know?
Well, certainly the court's going to consider all those circumstances. A couple of things. Mr. Perkins has some medical issues. He was shot several times. He has a femur that needs continuing care. He is epileptic. He was switched to epilepsy medicine that was somewhat different. I think it may be, well, he can speak to that more so, but what I really asked the court to consider is that he has a SSI hearing on May 12th at 1 o'clock. He is represented by counsel, Your Honor, and I think it's very important that he be able to participate in that. He's willing also to do what he needs to do for trial services. I can understand the court's concern that his residence would be all the way on the other side of the state. We'd be asking the court to consider a bond in the amount of $5,000 cash surety.
Mr. Robert, what's your position?
We would leave it to the discretion of the court.
Mr. Perkins, you live on Fairport Street in Detroit?
Yes, Mr. Middleton.
I can't hear you. Lean forward if you would. And where's Fairport Street?
Fairport Street is in Detroit, Michigan.
Yeah, what are the biggest side intersections? What's it near?
The bigger intersections are between 7 Mile and 8 Mile.
All right. What's the north and south road?
To the north and south road, Van Dyke and Shaner.
All right. I used to live in Detroit for a period of time. And inside of 8 Mile is the city. All right. What do you do there?
Well, they're at home. So there's really not much to do, but you know, I help the neighborhood out with their lawn. During the winter, I shovel snow. Like now it's spring, so quite much a lot of grass to be cut. You know,
Who do you live with? Who do you live with?
I live with relatives.
Which relatives?
I have a 16-year-old brother I live with, a 27-year-old cousin, and a 17-year-old cousin.
Bunch of young. Are there any adults in there besides you guys?
No, sir. I will be the oldest, practically the only adult in the home.
How old are you?
I'm 30 years old. I'll be 31 in August.
This whole thing is kind of shaky. The car's reported as stolen. I'm really interested to know what you were doing here in St. Joe County. You didn't have a valid driver's license. You got an ID card. They didn't charge you with driving without a license. It went to a rental company. Inside the car, they had multiple credit cards with different names on them. A key fob from a Jeep Wagoneer, which did not belong to that vehicle. A set of keys that also did not go with the vehicle. Prescription for some prenatal medication in the name of Linda Howard, and 5 loose rounds of ammunition in the vehicle. Not much of a much. All right. I will allow bond to be reduced to $5,000 cash or surety with all the same conditions. And pretrial supervision. I'm also interested in who Linda Howard is.
That is his deceased grandmother.
Prenatal medication for Linda Howard. I don't know what's going on here, young man, but $5,000 cash or surety bond for this should be sufficient. If you do post it, you need to make contact with community corrections and make all your court appearances.
Oh, I'm sorry, Judge. That was the complainant. That was the prescription that was returned to the complainant. The car was rented to someone. One of the debit cards is his deceased grandmother's.
Okay. All right, Mr. Perkins, you've waived your preliminary examination. I'll file it. And Josh, I think you need to process that for you. I get it. You're good to go, sir. Stay in contact with your lawyer, and if you do post bond, you need to contact the community corrections office. All right, I think that's everything they gave us to do this morning.
Yep.
All right, you guys are good to go.
Thanks, Judge.
Josh, there was a prelim set for this afternoon. I think, did it settle?
A waiver.
All right, very good. Judge P will be happy about that. All right, we've been in this chair since 8, it's now 11. We will have sobriety court this afternoon.